Hello, hello, hello.
Good so far. Okie doke, I'll hurry up. I just asked Sean Roderick to let us know if
sounds like Susan is in the room, so getting ready. Okay, let's start doing our introductions then. Or do we need to wait till she's actually on screen? We're okay to start.
I think so.
Okay. Good morning, everyone. Welcome to the Friday meeting of the Criminal Justice and Public Safety Committee. I am Representative Charlotte Warren, and my co-chair, Senator Susan DeChambeau, is signing on momentarily. Let's start with introductions of the committee, and we'll start with Representative Costain.
Good morning. Thank you, Madam Chair. Good morning. Dan Costain from
used
District
to be
1.
easy. Mike Carpenter used to come from that, do it here for the time.
Thank you, Representative. Representative Lookner.
Morning, I'm Grayson Lookner. I represent District 37, which is part of Portland, neighborhoods of Strawwater, Libbytown, Nason's Corner, and Rosemont.
Representative Pluker.
Thank you, Madam Chair. My name is Bill Pluker. I come from House District 95, which represents Hope, Appleton, part of Union and Warren. Thanks so much.
Thank you. Representative Rudnicki.
Thank you, Madam Chair. I'm Shelley Rudnicki. I represent House District 108, which is Fairfield, Mercer, and Smithfield. And I am here under protest because we voted that we finished our work last week. So thank you.
Thank you, Representative. Representative Newman.
Yes, thank you. I'm Dan Newman, District 76, which is Belgrade, Rome, Mount Vernon, Fayette, Vienna, and Wayne.
Thank you. Representative Pickett.
Good morning. Thank you, Madam Chair. My name is Dick Pickett. I represent House District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru.
Great, thank you.
The senator stepped out of the room for a moment. She'll be right back.
Okay, thank you. Jane, what's the rule? Can we go forward or do we need to wait?
I think we need to wait because the rule actually refers to starting the meeting, so.
I thought so. Okay, so let's hang tight for a second. Thank you.
We could, if you'd like, you could tell us which bill you want to hear first, and Deb could move people over.
Wonderful. Thank you.
If there's anyone you want to have.
Yes, thank you. Representative Pickett and I just spoke, and we decided together that we would like to work LD 539 and LD 573 together. They're very similar. The plan would be to hopefully use one of those vehicles as opposed to both of them. And then we would do LD 546 after. Okay. And then at the 1 o'clock hour, just so people know, we'll start with LD 769. Then we'll do 782. And in the afternoon, I think we'll go with, in the same order, we can just take mine last because I'm going to be here anyway. Unless we find ourselves looking for a sponsor, then we can plug mine in as we need to. So that's sort of the plan at this point.
The senator's in the room now.
Okay, great. And you all saw that Jane posted the bill analysis under committee materials, if you're looking for those. Okay, great.
Hello.
We can hear you, Senator, but we can't see you.
Again, you can't see me, but the other committees can see me. There's something with the video for this committee meeting. I don't know why, so. Did you guys work this out? What is this? So you don't even see my name anywhere?
No. Oh, you're Deb Fay. Okay.
Oh,
Me
that's
too.
right.
I'm fixing
Okay.
that now, sorry.
Okay, thank you. If you want, if you can, there's
Yeah,
the,
go over and click on.
I did.
Her camera's not on.
Says on the, your camera's not on, it says.
Where's, on the other committee I was on.
Yeah, you're gonna have to go to where your settings are.
We're having some minor technical difficulties.
That's okay. We'll have patience. I figure it's going to happen to each of us. It'll just take turns, right?
It's always more fun when you can watch the other person. Dan Costain looks very, very, I don't know, he looks very deep in thought right now.
Are you up north, Representative Costain?
Yes, I think it's gonna be a crazy weekend and therefore, what I get done.
Yeah, I understand that for sure.
Right across the hall, I would
Try shutting down the district.
You going to camp this weekend, Representative?
I'm not. I have too much work to do. I want to, it's, you know how this works, right? All my bills are next week. So I've got to spend the weekend preparing.
My problem is all these computers are different. I'm not a computer person.
I can't even open it.
Well, I'd like to get going. I wonder how to deal with this.
You want me to put my books?
Senator,
I can't even.
Senator, you want me to send you the link like I did day before yesterday again, and you can just try that?
Oh, I don't think she can hear you. Victor.
Representative Warren, would it be possible for Senator DeChambeau to properly mask, appear in the same window as Representative Pickett?
Appropriately masked? Yes, absolutely.
I can put her on speaker for now too, so she can hear, or just put it, unplug my headphones so she can hear what's going on while she's trying to do that.
That would be great, Representative. Do one of you mind if she could just come into your space for a second to introduce herself?
Hold on.
Thank you.
Senator, would you just look and introduce yourself?
Oh, you want me to?
Yeah, that way they can start the meeting.
Hi there.
Hi.
Okay, are you hearing the feedback?
No, you can
Okay,
The mic.
just talk, the mic's in it.
okay. I am Senator Susan DeChambeau, District 32, from Maine, right? From Dayton, Alfred, Lyman, Arundel, Kennebunk, and Biddeford. And I'm working real hard to get this going. Talk to you in a
Great,
bit.
Senator, thank you. Okay, so let's get started. Yes, Deb, could you bring over both I just saw your text message, I apologize. Could you bring over both of the sponsors?
Will
So,
do.
thank you. Good morning, Representative Corey, and good morning, Senator Miramont. The plan for this morning is that we're going to work both of your bills together because you have very similar bills. So thank you for being here, and we'll start off with Jane going over the bill analysis of both bills, if you don't mind, Jane. And I know that means you'll be sharing your screen to do that.
Ready? So just going numerically, I'll start with 539. This is LD 539.
Okay, somebody has a TV or a radio. Could you mute yourself? Or Deb, could you? Okay, thank you.
Okay, so this is Senator Miramont's bill, and it requires an applicant for a law enforcement position to provide the hiring agency with a written waiver authorizing release of all performance-related employment records, but not including medical pay and other non-performance data. It protects the agency that releases the information and the agency that gets it. It requires the hiring agency to conduct a background check on the applicant, prohibits the hiring an applicant who does not sign the waiver, and it requires the hiring agency to do a thorough review of disclosed employment records prior to offering or beginning employment of the applicant. And the bill prohibits the hiring of an applicant who declines to sign the waiver. There were a number of issues raised in the public hearing. I'll scroll down through a few of them. If you need me to move the document, I certainly can do that. It is posted under testimony with all the other bills. You can see that there are some issues raised about who the employer is. Rebecca Graham from the Maine Municipal Association provided information to you that in some communities, it is the municipal officers and elected officials who are the hiring agencies, not the law enforcement agency. So the hiring is done at the municipal level, not within the agency. She also mentioned the function of confidential records of protecting other parties in addition to the applicant, the law enforcement officer. The Maine chiefs of police noted the state civil service code providing confidentiality of records of people employed by state agencies. They noted a possible chilling effect on future internal investigations if confidentiality is not guaranteed. They noted that the waiver application only covers employment as a law enforcement officer within the last 90 days. If there was employment prior to that, it doesn't cover that. It also noted that the backward looking does not cover law enforcement officers who are not currently employed. Brenna Brissel, who is the director of the Bureau of Human Resources, spoke neither for nor against. I apologize for all the typos that you see in these today, but anyway, they're free. She did talk about records that predate employment, also such as letters of recommendation, examinations and evaluations, and criminal record checks, and polygraphs that are done before hiring. I'll let you take a look at some of her other observations there. And Senator, the last thing I would say is Senator Seaway asked if the bill could be broadened to include school teachers and all private sector employers. Where would you like to go at this point?
Thank you. Any questions for Jane about this specific bill analysis? And if not, we'll move on to Representative Corey's bill analysis. And then remember that we're going to hear from Sheriff Joyce this morning. We had decided that together during the public hearing. He couldn't be there. So here's Representative Corey's bill.
Okay. This bill requires a law enforcement officer or corrections officer who applies for employment with a law enforcement agency, correctional facility, or county or regional jail when they are employed by or within the prior 90 days were employed by another law enforcement agency, correctional facility, or jail. It requires the hiring agency to request their personnel records, employment records, and internal investigation records from the prior employment. It requires the applicant to sign the form and waive any rights they might have to privacy. The bill also directs excuse me, the Board of Trustees of the Criminal Justice Academy to adopt rules for the request and the waiver form. The bill requires the current agency to promptly release the information and provide civil and criminal immunity to both agencies. In addition, the bill requires an agency, facility, or jail that performs a polygraph exam on the applicant to notify the head of the agency, facility, or jail if the results indicate probable cause to believe the officer is or has been involved in criminal activity. I'll let you take a look at the testimony there. There were a number of observations of perhaps things that should be covered. The police chief's testimony was similar, and Brenna Brissel's testimony was similar to her testimony before. Shall I put that one down?
Questions from anybody about that one? Okay, I think we're good with that, Jane. Thank you. So let's hear from Deb. If you could bring over Sheriff Joyce. We'll all remember that this bill was brought to Representative Corey by Sheriff Joyce. He was unable to be here. And we decided together that we wanted to hear from him at the beginning of our work session. So good
He's
morning.
just coming in.
Great, thank you. Good morning, Sheriff Joyce.
Morning. I'm waiting for my video to pop up.
Okay.
Oh, here we go.
Great.
There, can you hear me?
Yes, and we can see you. Thank you. Welcome.
Thank you. Thank you for having me. Good morning, Senator DeChambeau, Representative Warren, distinguished members of the Criminal Justice and Public Safety Committee, as well as Representative Corey. My name's Kevin Joyce, and I'm the Cumberland County Sheriff. Before I start, I want to express my sincere appreciation for allowing me to testify on this bill. I was passionate about this because for about 12 or 13 years, I've struggled with the ability to try to let a parent organization know about something that comes up in a polygraph of a candidate that I may be looking at, and find out that I passed them over, yet my attorney tells me that I can't give that information to the individual's chief. So currently, polygraph examiners are required to notify the Maine Criminal Justice Academy if they find something that would be considered against the law or potentially against the law. They have to notify the Maine Criminal Justice Academy, and that information is kept there. And the way I understand it is that if I were to hire somebody, or if I knew my candidate was going somewhere else and for some reason didn't pass the polygraph, if I called up to the academy with a wink and a nod, I'd get, well, that person didn't pass the polygraph, or they failed the polygraph. And I couldn't get any more information. Well, that causes a chief to start wondering, do I have a problem lying in wait? And really this came about 13 or 11 years ago. I had two cases where we had individuals working for other agencies that took polygraphs, one to be an employee of the Cumberland County Sheriff's Office. That was the first one. And when we did that polygraph and I was reviewing it, I was chief deputy at the time, I was reviewing it, and I found that the individual worked a side job at a bar, and he admitted during the polygraph that he was present when drugs were being used, and potentially, he didn't commit to it, that there might have been some human trafficking going on. And so we didn't hire him. And so I called our attorney and I said, we didn't hire him, and I've got some concerns because I really don't think he should be in law enforcement. And I surely don't want to be the chief who has somebody working for me and come to find out that the person's potentially getting arrested or rounded up in a warrant, or I'm doing a press conference shocked that one of my officers has potentially been involved in something. But I was told by the attorney that unless I want to get sued, I can't say anything about it. So I never told the police chief about this case. And again, in my opinion, that's a problem lying in wait for that potential chief. I don't think anything ever happened that is tied to that particular department. But to this day, when I see that chief, I feel a little bad that I didn't share that information, because I would want the same and not be blindsided by something that somebody knew. But because we were afraid that we might get sued by sharing that information legitimately, that would occur. A couple of years later, not too long after that, we had another individual who took a polygraph to do a specialty team that we offer. Didn't work for us, but we did the polygraph. And this particular person had some mental health issues to the point of suicide ideations. And I didn't accept that person. Well, this person had been sponsored by his chief. So needless to say, when he found out that we weren't taking him because of the polygraph, that causes a problem for the chief wanting to know, well, why didn't we take him? And I remember the chief coming down and sitting in my conference room, and he's trying to you got to tell me. And I go, my attorney's telling me I can't. And I never did. Now, this individual didn't stay on the law enforcement, that agency long, and they got completely out of law enforcement. But, at a time when we're looking at the credibility of our officers at a time when we're really starting, and we have to be concerned about mental illness amongst our ranks. Number one, because we don't want them doing something bad. But number two, it's an illness and we want to get them help, and surely don't want them, if they're suicidal, to carry through with that. This is sometimes our opportunity to maybe get that person some help and at least remove them from the profession if it's that bad, so that nobody gets hurt, including the individual. So in that bill, I'll admit it was somewhat plagiarized from the North Carolina Sheriff's Association, because I liked the last two paragraphs regarding polygraphs, and really holding me, if I find something in a polygraph, that I'm indemnified from civil liability because I reach out to that person's chief and let them know that they have a problem potentially lying in wait. That doesn't mean the end of the career for that person. It could be the fact that we maybe save that person's career if we stop poking around, and maybe it hasn't got to a level of a crime or anything else, but we've got something in a polygraph that the individual is voluntarily given us by virtue of being questioned. So I've really struggled with these two cases. To be honest with you, it's not going to affect 99% of the hardworking guys and gals that go out and do police work each and every day, unsure if they're going to come home. But it is going to root out some bad police officers if by chance they're acting as a full-time law enforcement officer, and after they did that first polygraph to get them into the profession, they start doing things that potentially could be illegal, definitely unethical. We can try to root some of those individuals out. I've met with, or some of the police unions, 5 individuals I met with prior to March 26th. They called me because they had some concerns about, I think, 539, which I really didn't know anything about. And it may be the first paragraph of 537. And they were concerned about, am I trying to look at how many times a person has filed a grievance? And I said, no, I don't care about that. If somebody's been investigated for showing up late at work, that's a problem, but that isn't a problem that I'm trying to look at. The issues I want to be able to do, and we even got to the point of my first scenario with this bar. I think we can look back a couple of months to, an officer who was arrested down in Washington County. And if you track that person along, they were moving around, and there's a lot of winking and nodding and trying to get messages amongst chiefs. But the bottom line is, at least from my attorney's standpoint, that it's only good until somebody makes a case and then you get sued. For the mental health, one of the union reps said, well, geez, I really feel like mental health, somebody could lose their job. And I said, if I've got an officer that is suffering, that might be my first and only attempt or chance to be clued in on it. And I don't think I'm going to fire him right off the bat. We're going to get him help. Maybe at some point somebody says that the person shouldn't be in law enforcement, but maybe, just maybe, we've saved a life, because this particular guy, his suicide ideations were pretty close to a completed suicide. So I'm really passionate about this part, the front part about records and yada, yada, yada. I listened to 539. That is basically, if I'm in an agency and I want to go somewhere else, I'm sending all of my records that occurred in my agency that I'm in now. I'm talking about going backwards and letting the parent organization know that they have a potential person lying in wait. The first individual with a crime, maybe the chief didn't even know. Maybe the chief didn't even know to ask the academy. And quite frankly, even if he did, the way I understand it is they will just say, well, he failed the polygraph. Well, there's a number of reasons why you could do that, and most of them are bad. So really, that's what I'm trying to get out of this. I think this is an opportunity to take care of the very few people in our profession, at least in the state of Maine, and make sure that any cops that we have that are dirty, because the old saying goes, nobody hates a dirty cop more than a good cop. And we can root those individuals out before bad things happen. That's the end of my testimony. I'll definitely take some questions.
Sheriff, thank you for that. And let's have questions for Sheriff Joyce. Senator DeChambeau. Oops, you're on mute, Senator.
Okay now? Thank you. All right, thank you. I'll lower my hand too. Thank you for your testimony, Sheriff Joyce. It was worth the wait, especially. Thank you. I have a couple of questions, but I'll ask my first one for a clarification. You conduct polygraphs for your correctional officers?
We do.
Do you know if the state does polygraphs in hiring correctional officers?
I do not know that.
Okay. I would like to know that. I have never heard of that in the state, so that's fine. May I have a follow-up question, please?
Yes, please.
Okay. It almost sounds like what's on trial here is the value of a polygraph. I want to ask, you said that the polygraph exam goes, I think it's required to inform the academy of the results of that polygraph. Is that correct?
Yes, and any issues that, especially issues that either are criminal or could be criminal if looked at and investigated.
Now, is this for people who are applying for the job or someone who is asking to go to another department?
So if a candidate, the two examples were law enforcement, but let's say corrections. If a candidate, and some sheriff's offices do polygraph corrections officers, but let's say a candidate comes from another county and they want to work for us, we have a hiring process that includes the polygraph. If they've taken a polygraph within a year, then I won't make them generally go through another polygraph, because usually within a year that person is fairly new and probably doesn't stray. Anything over a year, I will have that candidate go through a polygraph. So when I find something, or my polygraphist finds something, or actually all the polygraphist does is ask the questions, determines whether or not the person substantially told the truth, because we're looking for people that tell the truth. Then we look at it, the executive look at it for, does the person's actions fall in line with the ethics and morals of our agency? And this is where it becomes a problem, because if we find something that really, really is bad, like the two examples, yeah, the academy would be notified. They will know the reason, but they won't be able to tell us. And I won't be able to tell their parent organization, another county, why I didn't hire them. Maybe the sheriff, I'm assuming is a sheriff, doesn't even know the person's applying. So he might not even inquire, or she may not even inquire. But the fact that I know that something's happened that's unethical, potentially illegal, weighs on my mind. Yeah, I guess I could try to get that message across, but if it comes out that I did that, the way it stands now, our attorney says that I could be sued. So that discourages me from sharing that information with a leader that could potentially have a problem lying in wait.
And that's what I've come to a roadblock on. The academy won't tell you, and you presume it's something illegal, or you might even come close to be correct. I'm more concerned that the academy has that information and they don't feel the need, probably their attorneys have told them to, first of all, decertify that individual. He may have passed the polygraph a year ago, and in that year, even as a badge-wearing officer, may have been involved in some criminal activity, and that you have asked, or anyone else has asked, for another polygraph because it's been over a year, and it comes back questionable. And the only entity that knows that there's a possible problem or involvement in criminal activity is the academy. And they leave you high and dry by not even sharing that information, but they know them. And that academy and the trustees are responsible for certifying and decertifying an officer. I'm questioning why the academy does not feel that they have the ability to decertify based on a polygraph. That's why I say what's at question here is the value of a polygraph. It's either good or it's used as a weapon or it's used as not hiring someone. So that's all I wanted to say. I wanted to clarify that. I'm really confused with the role of the academy and having that. They don't shy away from decertifying people, but in this case, I don't know why they don't. Because not decertifying, this guy is ready, this individual or correctional officer can go anywhere else. So
I can't speak for the academy, and I won't, because I won't claim to know everything that they do or their policies. But, you know, even if a complaint goes up there, there's a due process, and that due process doesn't happen immediately. So I'll go back to my concern. I give a polygraph to somebody and I'm not hiring them because I think they've committed a crime. I've got to send that information up to the academy and it gets processed, et cetera. But this individual just took the polygraph, is going back to his parent agency and going to work tonight. If something happens before that due process kicks in, then we're all doing that unavoidable press conference. And we're answering why we didn't know that. So I think the process, there is a process with the academy, and I'm sure that they would do that, but there's a due process to that.
okay.
My concern is the individual goes back to their parent organization and they're going to go to work tonight. And if tonight's that night that something bad happens, could we have avoided that?
Thank you.
Other questions for Sheriff Joyce? So I'll take a question, Sheriff. Thank you. My understanding, I want to say that I agree with Senator DeChambeau that there's an issue with the Criminal Justice Academy having this information and not doing anything with it. And I think we probably all agree with that. But I'd like to put that over in the parking lot because we're going to have a bunch of bills about the Criminal Justice Academy. And I think we can pick that issue up then, if you all agree. That is something we need to talk about. But I don't think it's something that this bill by the sponsor and the sheriff is going to deal with for us right now. The part that I also think is missing, and I don't know if we do these two separately or we bring them together, but I totally understand where you're sort of, you're hearing from your attorney that you're making yourself and your department liable by sharing this information, but you're sharing with us that you also feel personally liable. Like you now know this information that you can't share. And I totally get that. My question for you is, another piece I worry about is what if you have an employee, either corrections or officer, and you come upon similar concerns as the ones that you've shared with us. This bill that we're looking at from Representative Corey, 573, doesn't address those issues, right? As far as I understand, you still cannot share personnel information that may be of a similar ilk to the stuff you shared with us, and somebody's going somewhere else. And it looks like 539 attempts to do that. Am I right in that assertion, Sheriff?
I'm not sure you are.
Okay, thank you.
I'll use it for instance. I have a corrections officer, took a polygraph before they came in to be a corrections officer. They spent 5 years as a corrections officer. We try to promote within, and most of my law enforcement, over half of my law enforcement officers started in a jail. So they apply for law enforcement, full-time law enforcement. Well, to get into the academy, they have to do another physical agility, which they had to do 5 years ago. They have to do another polygraph because it's been 5 years. And with law enforcement, we have them do one other test, which is the psychological. That's the only difference between corrections and law enforcement. Now, let's say that I polygraph my corrections officer, and during that person makes some admissions that is problematic to me. That individual is not going to get hired as a police officer. And depending on what that person's made for an admission, I'm going to start an internal investigation, a criminal investigation, because that person has made admissions that is problematic, and I surely don't want that person going to another agency or whatever. So I can take care of the ones I know about. It's the ones, these two chiefs, to this day, 11, 13 years later, one's out of the business, another one's still in the business. When I see them, I feel a little dirty because I haven't been able to tell them about their problem lying in wait. And we should never have to be the wink and the nod. You know, if you ask me the right question, if you open the right door, you might get the answer that you want. We should be able to say, look, there's a problem here, and we got to remove this person from the profession. Or with the mental health, we need to get this person some help and get that person back on the right track. And again, sometimes when you file a complaint against somebody, it looks really, really bad, but maybe they haven't got to the point where they've committed a crime or completely followed through on something. And just by the inquiry, it stops the problem. And you may have saved that person's career. You may have saved that person from going to jail. You may have saved your agency or somebody else's agency from the relentless press conference that person has to have. So really, it really surrounds the polygraph and the chief that doesn't know what's going on. I feel like Bernie King. I'm sorry. I mean, Bernie Sanders with my hands. I don't know where it's coming from now, but maybe it's the passion. So did I answer your question?
You did. Thank you, Sheriff. Thank you. We have Representative Pickett has a question.
Yes, thank you, Madam Chair. Good morning, Sheriff Joyce.
Morning.
So the key to this bill is I look at it, and I'm looking at 573, I believe it is. I believe that's what we're on here. And the reason why I like this bill in comparison to 539 is because of the waiver. That's the key to me in the whole bill, because as I read about the waiver, number one, the Academy Board will have to come up with, using rules and stuff, will have to come up with a waiver that will be used by all. They are the ones that have the opportunity to certify or decertify officers and so on. That obviously is where that should be. So that this waiver now is going to protect you, I believe it would protect you as a hiring agent or as a agent who has a person who's leaving your employ and going to another department who is looking to get hired. It's going to give that freedom for you to be able to get that information, or vice versa. The information can be shared, but it still is not information that's just going to be floated out there to everybody in anything. It's going to be information which is going to be kept confidential between the two agencies to allow me as the chief of police in Dixfield to know whether I want to hire a deputy from Cumberland County Sheriff's Department because of the information we shared back and forth. And that is really key, which, would you agree that that makes the difference in this bill and really hits home for where the problems that you're facing and the feelings you're facing about not being able to take care of, to share information in these things, that the waiver is the real key?
Yes, and if you don't mind, I'll use when you were chief in Dixfield. Let's say one of your employees wanted to come to work for the Cumberland County Sheriff's Office, and during that polygraph, your employee made a bunch of admissions. Yeah, I show up for late. I show up for work late, 3 times, and yeah, I have 7 beers a week. That's not stuff that I'm talking about here. But if the person says, well, yeah, I have sold drugs out of the back trunk of my car in Dixfield, and you don't know about it, I think you should know about it. And I shouldn't be feeling like I'm going to get sued if I tell you, and the person somehow loses their job, finds a criminal case against them, that I shared that with you and I shouldn't have shared that with you. Does that make sense?
Oh, absolutely, because I not only think you should tell me, I need to know. I need to know about that, because I don't want this individual, nor does any police agency out here want that individual working. So I think this needs to be, we need to be able to craft this in a way that we can make this work. And I think the waiver is a big part of it. And I think the waiver needs to become part of the hiring policy for agencies in order for that to really be effective. Would you agree with that?
Yes, and I will tell you right up front, like I said, I plagiarized it from what the North Carolina sheriffs and police departments do. I just put that in there because I knew it would have to be massaged to what we do here in Maine. And I knew that other people would be looking at it. Like I said, for me, it's the last 2 paragraphs of that summary that really, if that passes, I feel like I've done the profession and my fellow chiefs and sheriffs justice, and at least being able to make sure that we've got good quality police officers that are working for our agencies.
Right. And I have family in North Carolina, so it must be a good bill. Thank you.
Yes.
Any other questions for the sheriff? Okay, discussion on the bill. Senator DeChambeau. Oh, you're on mute.
Okay. I want to like this bill, but I have a lot of questions. I think, number one, that first question I asked about correctional officers, we'll have to get some information to whether it's correctional officers in county jails. I didn't even know they did polygraphs. I don't know for a fact if our state correctional officers go through a polygraph. Never heard of it. Never heard of officers talk about it. I didn't get to ask the question, but I want to know what's the magic of 90 days prior. You can play with that 90 days. If you know you're going to have to sign a release form and get another polygraph, then you'll apply for the job at 120 days, so you're not subject to that. And there was another thing. Oh, the examples that Sheriff Joyce gave, the only experience I have of polygraphs is watching them on TV, right? In that I don't believe they ask questions such as, have you ever used or have a dialogue, and that the applicant would say, yes, I used drugs in college or what have you. I'm sure they ask the question and it's a yes or no. And if there's any evidence of not telling the truth, that would show up. What if the officer was asked the question if he uses recreational marijuana? It's legal. Would that preclude him from not having the job? So again, I want to like it. I just feel it has too many open-ended issues. And I thought that I read the testimony of the Maine Sheriff Police Association who brought up a couple of suggestions. So as written right now, I can't support this bill.
Okay, thank you, Senator. Representative Pickett.
Yes, thank you, Madam Chair. As I said, the big key for me in this, there's two things that make me want to get something done on this. The key to the bill for me is the waiver. That piece is really, really important to me. And that leads to the main reason why I think we have to do something with this. We can't have it both ways out here. We can't be continually scrutinizing the police for saying they have bad cops, they're this and that and everything, and then turn around and then have something that we have here that will allow agency heads to work together. And if there is, and they are few and far between, but if there is somebody that should not be in the employ, that they can deal with it there before it becomes an issue. So, you know, I really think transparency seems to be the key word out here when it comes to law enforcement right now. There's a big push on that because of what happened around the country, not here in Maine, but happened around the country over the last year. But I understand that, but I really, really believe that we have to give a tool to our law enforcement officials, regardless of where they are, to be able to dig down when someone is looking to be employed by them. That being said, the only possible problem I see here, and I don't know if it is a problem, what about the chief of a municipal department? Because I was hired, just like Rebecca Graham said, I was hired by the board of selectmen in that town. So what about the sheriff? The sheriff is elected by the people. The commissioner of public safety, who is head of over the hall, you know, the people that are in that position. I think we have to just be sure that when we look at law enforcement people, we're looking at law enforcement as a whole if we really want transparency. So I don't know if that's an issue for this particular bill, but I just think that is a concern I have. Although I like this bill very much, and I really like the waiver part. And if we can use that waiver, and if the person, but I don't know if we cannot dictate to a municipality, I don't believe, maybe we can, to put a waiver form in their hiring process. So that could end up being a problem here, but that's my thoughts on it.
Thank you, Representative Pickett. Others? Yes, the sponsor, Representative Corey, what do you have for us?
Thank you, Madam Chair. So after listening sort of some of the deliberation on this, it seems like you're gonna, need to take some time, on it and really kind of, delve into at least what corrections is doing and what's happening at the academy and everything else. I think it's kind of funny that, Senator Miramont and I kind of put in very similar bills in a lot of ways. So that must mean that this is coming from a good place. So, I have a lot of faith in the committee, especially since it's my former committee, to really look at this and make something, good out of it. I'm not going to, pretend to understand, how those two bills, should that be melded together without, having all the information that you guys will obviously need in order to make that happen. But, I'd like to encourage you in that process and, hope that you're able to, come up with something that'll improve this. It seems like, Sheriff Joyce had some, sort of very, deep, concerns, not only, with the people he's hiring, but, also, the difficult situation he's put in, personally and struggles with while doing this. So I want to thank you for, taking the time with the bill and just encourage you to, come up with something good. And I believe that both, Senator Miramont and I, would like to see that. Thank you.
Thank you, Representative Corey. Senator Miramont.
Thank you, Madam Chair. Yes, I agree with those sentiments. I'm never here to get credit. So however you blend it, whoever you give it to, that's wonderful. I did hear a question by Senator DeChambeau that was also on my mind. I thought the 90 days might be some kind of tool that was necessary in there. So I kind of didn't challenge that, but I feel like I should have. I think if there's a way to game it with the 90 days, that we shouldn't be allowing a loophole with something that all across the spectrum, from a sheriff to someone who's out here trying to do some other criminal justice reform, are all saying there's a need, then why limit it at 90 days? So just while you're thinking about that. And I certainly was not thinking about the part with the Criminal Justice Academy yet. I have Criminal Justice Academy bills, but he tied that in nicely. It's the same thing. Either the former chief or whoever gives out information being able to give it without fear of liability, because it's an essential bit of information, or the chief looking to hire being able to ask any source, whatever that exchange is to get those good officers that we have and need. That's all I want to do. And thank you for the chance to say that.
Thank you, Senator. As much as I want to vote on one of these bills today, it feels like we have a need for more information. Do people agree with that? No, Representative Costain, you don't.
I think I could be prepared to vote on one of these bills. I think the information that Sheriff Joyce has said and Representative Pickett, and I sort of agree that I think we could move forward with one of these, but I'm fine with tabling it as well if people feel they need information. So
I want to make sure the part that that the sheriff MMA brought up, and then Representative Pickett just highlighted to us. I do know that in a lot of situations, as far as municipal officers, it would be either the Board of Select Persons or the City Council. So I think we need to make sure that that language, just so that we're being fair across the board, maybe we can do that in an amendment now. I'm not opposed to that. Jane, I do have a question for you, and then I see that we have Senator DeChambeau has her hand up as well. And Senator, if I may ask this question and then go to you. Jane, I'm struggling a little bit with where the biggest difference is between these two bills. They both have the waivers, but it sounds like I had it wrong earlier, where I feel like the 573 was around the polygraph, but now I'm understanding, does 573 also allow a sheriff to share stuff that's happened while the person was on the job, not necessarily connected to a polygraph? Because that's the part that I think was important about Senator Miramont's.
Yes, they both call for the sharing of information.
Awesome.
But there is a difference, and that is Senator Miramont's bill requires the release of all performance-related employment records, but not including medical pay and non-performance data. That I believe the Representative Corey's bill calls for the release of personnel records, employment records, internal investigation records. And so there's a difference between them in what they ask for. And Senator Miramont's has the exclusion of certain medical pay and non-performance data. So he actually has some exclusions. Maybe, I mean, I would be happy to work with both sponsors to see if we could work out an agreement between the two of them on those, just on the information, if you would like.
Thank you for that, but I think I have a better understanding, and I think that the way that the sheriff and Representative Corey have outlined the information to be shared, in my mind, is the proper information to be shared.
Fine.
I want to just get a sense of others. Do we agree on that? Okay, I see heads nodding. That's okay. So that's helpful. Thank you, Jane. I get the difference, and I would support what Representative Corey's bill says. Senator DeChambeau. Oops, you're on mute.
I hope this is my last comment here. I reread the Maine Chief of Police testimony, and not only that, something Sheriff Joyce said, that the Academy attorney said, I can't tell you. I don't know what the basis is for an attorney to say that. Probably it's human resources based, but I'd be interested if Ms. Overton can find out on what basis he can't say. But the issue is the Chief of Police's testimony said about confidentiality provisions in the Statute of Civil Service, and that's MRSA 57070, and even gave a suggested remedy if that statute would have the title notwithstanding, it might allow it, but it seems that it's prohibitive because of the statute. So the other one, the Senator Miramont's one, I didn't see it under the underline, but the summary said, including sealed records, especially of your performance. When you talk about releasing sealed records of disciplinary action taken on officers, and that's part of their work, and they're sealed, you've got to deal with the union also. They're sealed for a reason. I would not want to work for any company that I knew that what I did, and I was slapped on the hand and maybe had a suspension, and that record is sealed, that if I wanted to leave, that would then be reopened. So that bothers me on that one. So that's the last comment I want to make. Thank you.
Thank you, Senator. I think we have agreement that we would use the definition of materials from Representative Corey's bill, not Senator Miramont's bill. So that might take away that concern for you. Representative Pickett.
Yes, thank you, Madam Chair. I think to clarify for the good senator, I think that Sheriff Joyce said he was told by his lawyer. I didn't think he said the academy lawyer. I think he said his lawyer that he couldn't release that. I may be wrong, but I think he did.
Said both.
Did
I
he?
think.
Okay, I only heard that. I just thought maybe that might clarify that for you. As much as I want to pass one of these today, and I do, I have to listen to the sponsors. And I think we need to do it and do it right. Because we don't want to do something and find out that there's something in there we should have tightened up before we did it. So that being said, I can't remember whether making those comments, if I can make a motion or just, I have to say that and get off. I'm really not sure. I'm going to make the motion. If I'm out of order, tell me. But I
Okay,
would
not
move-
quite yet. Can you hold on one second, Richard? Do you
Okay, I
mind?
will.
And
I
then
will.
We'll let you make the motion. Thank you so much.
Okay.
I wanted to float the idea just so that while we're getting ready for this motion, a couple of things. I want to make sure that people get a chance to ask for what they need from Jane. But also, what do you all think about the idea of going from the 90 days to 6 months? And since we're going to come back and work on it, maybe you think about that. And Representative Corey, do you have any thoughts about that right now? Okay, so that's something I would like us to think about. What do you all committee members need from Jane before the next work session? One of the things I'd like to ask that we find out is why don't corrections workers have to do the psychological? So Sheriff Joyce mentioned that there are.
I'm sorry, Charlotte, I don't want to answer your question, but.
I think you do.
Well, I'm holding off, okay, if you don't mind.
No, go ahead, please.
He clarified that the psychological is for law enforcement officers, the patrol officers. Any law enforcement officer gets a psychological. I do not recall him. I was surprised that correctional officers had polygraphs, but no one gets a psychological.
So my question is, why aren't corrections officers getting the psychological like law enforcement? I'd like to know that. Do you see what I mean? Do you understand my question? That I'm wondering why they don't.
I'll let her ask the commissioner, but that would mean I would have had to have a psychological, and mental health should have a psychological. There's a lot more people dealing with prisoners than just correctional officers.
And I still stand by my question, even though it may, have something to do with you personally. My question is more about the state. So I'd like the answer to that. Any other questions from anyone or things that you need? Yes, Representative Pluker.
Thank you, Madam Chair. I was just looking at the testimony that Senator DeChambeau referenced from the Maine Chiefs of Police, and in their third paragraph, they're referring to the notwithstanding clause in Section 5 MRS 7070. Either having language around that or having an explanation as to why that's necessary or not necessary would be great.
Thank you. Great point. Anyone else need anything else? Yes, Representative Newman.
I just wanted to, if nobody has anything else, I just want to make the motion to table these two bills until we can.
Perfect. Would you mind doing them one by one? Representative Newman, would you mind doing them one by one? Thank you.
No, I'll make the motion to table LD 573.
Do I have a second? Seconded by Representative Pickett to table LD 573. And Deb will, do we need to do a roll call on this? Yes, Deb will call the roll.
Committee members, please turn your video on and unmute for a roll call vote. Representative Warren.
Yes.
Representative Morales. I'll circle back. Representative Reckitt is absent. Representative Sharp is absent. Representative Lookner.
Yes.
Representative Pickett.
Yes.
Representative Costain,
Yes.
Representative Rudnicki,
Yes.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Senator Lawrence is absent, Senator Seaway is absent, Senator DeChambeau,
Yes.
Representative Morales is absent. So that's 8 in favor and 4 absent.
Thank
Five
you. Thank you, Deb. Representative Costain.
Thank you, Madam Chair. Before we table the other one, I asked Sheriff Morton why they don't have to do psychs on correction officers, and he said that's not a standard from the academy. So therefore, it does not have to be done.
Thank you so much for that. Jane, while you're keeping track of things for the Criminal Justice Academy bills, could you put that on there? And also Senator DeChambeau's earlier question about polygraph information going to the Criminal Justice Academy and not being shared. And then we can deal with those when we get to that sort of suite of bills. Thank you. Representative Newman.
Yes, thank you, Madam Chair. Actually, we've got a quick question. Do we want to table LD 539 or do we want to fill that bill to work on the other one?
I think we want to table it. I'm still not convinced we don't have some things that we might be able to use it as a vehicle for.
Okay, I'll make a motion to table LD 539.
I'll second it.
Thank you. Motion made by Representative Newman, seconded by Representative Costain to table. All those in favor? Deb?
Okay, video on and unmute, please, for a roll call vote. Representative Warren,
Yes.
Representative Morales? Not back. Representative Reckitt is absent. Representative Sharp is absent. Representative Lookner,
Yes.
Representative Pickett,
Yes.
Representative Costain,
Yes.
Representative Rudnicki,
No.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Senator Lawrence is absent. Senator Seaway is absent. Senator DeChambeau.
Yes.
I'll circle back to Representative Morales. Still absent. So that's 7 yes, 1 no, and 5 absent.
Thank you very much, Deb. Thank you, Senator Miramont and Representative Corey, for your work on this. And Sheriff, if he's still here, thank you as well. We'll see you soon, okay? Up
Thank
next,
you.
thank you. Up next, we have LD 546. And Deb, whenever you get a chance to bring Representative Brennan over.
Representative Brennan is not in the waiting room yet. I texted a few minutes ago.
Wonderful. Let's just take a quick second. I also sent him a text, so I know he's on his way. Thank you. Oh, he's in the attendees. Good morning, Representative Brennan. Thank you for joining us.
Good morning, Representative Warren, and I can't tell you how excited I am to be here. And
Perfect.
that just tells you what's going on in the Education Committee.
Thank you.
And I've also had a chance to be in Health and Human Services this morning as well.
Great, you're making the rounds.
So I'm touring all the different committees.
Perfect. Well, we're ready to pick up your bill. And so we'll start with Ms. Orbiton walking through her bill analysis for us all.
Okay, this is LD 546, an act to implement the recommendations of the Maine Juvenile Justice System Assessment and Reinvestment Task Force. This bill has a number of different sections there. Some of them, they are interrelated, but Representative Brennan did a fine job taking you numerically through them when he presented the bill. So I will only just remind you, and I won't read you these descriptions. But Section 1 repeals the law that allows pre-adjudication detention of a juvenile based on the lack of a parent or other suitable person to supervise that juvenile adequately. This is what I think sometimes referred to as the homelessness basis for detention. Section 2 establishes some benchmarks for daily populations of detained youth and committed youth through July 2024. Section 3 reestablishes the Juvenile Justice Task Force to work with JAG and the stakeholders and the Department of Corrections and Department of Health and Human Services on a community-based system. Section 4 requires annual reports from the Department of Corrections to the Criminal Justice Committee on, and there's 7 different items that have to be in those reports. Section 5 requires a report to the Criminal Justice Committee on possible locations for 2 to 4 small, secure therapeutic residences for youth for the purposes of providing detention and confinement for a maximum of 20 youths total. Section 6 requires DOC to provide ongoing funding to community-based nonprofits that provide therapeutic services in order to divert youth and reduce commitment. For the same purposes of divert youth and reduce commitment, Section 7 requires DHHS to provide ongoing funding. Section 8 provides some of that funding. And the bill actually provides $2 million in funding. I guess I didn't write it down. I think that Representative Brennan suggested an amendment, right, Representative Brennan? That would reallocate that funding, and I seem to have somehow lost that. There was a good deal of testimony on the bill. I'll scroll down and let you look at it. There was testimony in favor, testimony opposed. And then there was some neither for nor against, with people endorsing part of the bills, but not part of the bills of the bill. And so I'll leave that to you. You know that you can find this under the testimony, under the committee webpage. The bill analysis is there.
Wonderful.
That's it for me.
Thank you, Jane. Before we dig into the conversation, any questions for Jane from committee members? Okay, seeing none. Thank you, Jane. We can stop the screen sharing when you're ready. Thank you. Representative Brennan, anything to add before we dig into our conversation?
Thank you, Representative Warren. Just a couple things very quickly, just to clarify Ms. Orpington's report. My amendment called for $1 million to the Department of Corrections, 500,000 to the Department of Health and Human Services, and 500,000 to the Department of Education for restorative justice programming. So I think there was one part of that got it and the other part didn't. But,
thank you.
But that was the intent. And secondly, there were some additional language suggested amendments in terms of the task force and the juvenile justice advisory group. And I think Ms. Orpington does have those. There were more edits than anything substantive. And then there was also a recommendation from Jill Ward about including a strategic plan by the department in regards to juvenile justice. So my hope would be that we'd get all those amendments and all that language into one place, which I think Ms. Orpington has done the lion's share of that at this point.
Great. Thank you, Representative Brennan. All right, so committee members, now it's up to us. And we have folks that are here as attendees that we can bring over if we have questions for them. Who would like to kick it off? Representative Pluker.
Thank you, Madam Chair. Representative Brennan, could you just kind of lay out for us why you think the idea of emptying Long Creek within 18-24 months is better than kind of moving forward with closing Long Creek on a definite timeline?
Representative, you're on mute.
I just unmuted myself. There are a couple of things, Representative Pluker, and thank you for the question. One is that obviously in the last year we've seen a pandemic, and if we had tried a year ago to put a timeline to the future use of Long Creek, we probably would have been off for a year due to the pandemic. So there are a number of different factors that come into play, and I think it's important at this point to focus on developing what we need in the community, the services that we need in the community, and the capacity that we need in the community that reduces detention and incarceration, rather than attributing an arbitrary timeline to quote the closure of Long Creek. I do firmly believe that if this legislation is adopted and we go forward with this legislation with the Department of Corrections and with community providers, that there will no longer be youth incarcerated or detained at Long Creek within the next 18 to 22 months. But there are a lot of intervening factors, whether or not there's a $2 million appropriation, and whether or not some of the other key features that we need in that community-based system, how quickly they can come online. And so, for example, I'm optimistic that we can get these residential programs to come online, but it also means that we need to engage nonprofits. We need to make sure there's staffing, and we need to make sure that the resources for those programs are available. So, I can give you my best prediction, which I think is a pretty good prediction of what will happen with Long Creek, but I'm not wedded to putting in the statute at this point a date for quote closure.
And a follow-up, Madam Chair.
Yes, you may.
And you kind of feel like DOC is the best place to coordinate that effort and distribute those funds. Why do you feel DOC is the best place to distribute that community programming funding?
Well, the simple fact of the matter is that when youth become involved in the criminal justice system and end up either in the court or the criminal justice system, they do come under the jurisdiction of the Department of Corrections. So it's kind of hard to transfer that responsibility to another state agency or an entity within the community. So I think that Department of Corrections, has to play a role in making determinations about how we build out this community-based system and what the future of Long Creek is going to look like. At the same time, it's beyond question that the involvement of the Department of Mental Health, Department of Health and Human Services in terms of mental health issues, substance use issues, is critical for us to build that community-based system. And as I've mentioned before, the involvement of the Department of Education is also critical. And I think I probably mentioned that at one point, 50% of the adults in our state prison are high school dropouts. So if we did a better job of keeping our youth in school and being successful in school, the chances of them ending up in the juvenile justice system and subsequently in the adult system are greatly reduced. And I'll just add one other side of this, Representative Pluker, because this is important to me. But the general population in the state of Maine in K through 12 education, about 18% of students have IEPs for special needs, 18%. At Long Creek, it runs between 60 and 70% of the students have IEPs for special education. So that's a clear indication that there are youth that struggle with special needs, some that are unidentified, some that are identified, but it leads to them struggling in school. And unfortunately, when students struggle in school and then leave school, the criminal justice system unfortunately becomes a place where they end up far too often. So I think simultaneously working with Department of Corrections, Department of Health and Human Services, Department of Education to develop these different strategies and the community-based programming that we need is critical.
A follow-up, Madam Chair, I'm sorry.
Yes, please.
You had mentioned that diversion needs to happen before we can close, but then at the same time you said that DOC should be in charge of kind of running that diversion, and the DOC is the best place to coordinate that work because they're going to become system involved or because they're the best ones dealing with youth who are system involved. But if we're talking about diversion, then hopefully they never even have to deal with DOC. So that I was hearing a little bit of a contradiction, if you wanted to help me with that.
Well, some of the words that you used were your words, not mine. But again, depending on how far back we want to go and have this discussion, I mean, clearly having more restorative justice programs in schools, having more support in schools, and doing more to reduce suspensions, expulsions, and pushing youth out of school is a great diversion strategy and tactic that I think we should pursue. There are also a number of youth that get involved in the juvenile justice system that have significant substance use issues, mental health issues, and other behavioral health issues. And those, many of those can be addressed through the Department of Health and Human Services. But ultimately, as I mentioned, when you have a youth that becomes involved in the criminal justice system, juvenile justice system, involved in some activity that ends up in court, that does come under the jurisdiction of the Department of Corrections. and they have to make decisions when judges commit a youth to the Department of Corrections or to Long Creek. So it's hard to remove them from the process of playing a role in diversion, as well as the role that they play at Long Creek. And I do think there's a considerable amount of expertise at the Department of Correction that understands the importance of diversion and understands how to create a well-integrated community-based system to assist those youth that end up in the juvenile justice system. So the only thing I'll quibble with you about, Representative Pluker, is the use of the word best. And I'm not going to say that Department of Corrections is the best or that they're the worst, but I do believe the best is having a collective effort between DOE, Department of Education, Department of Human Services, and the Department of Corrections. And unfortunately, in the past, we have tended to silo a lot of the work in juvenile justice to the Department of Corrections. And we haven't been able to successfully integrate those parts of DOE and DHHS into the work of Department of Corrections. And I hope this bill will be a significant step forward in having that type of integration.
Thank you.
Representative Rudnicki.
Thank you, Madam Chair. And I missed the first part of coming in on this, so please forgive me if this has already been asked. Representative Brennan, have you spoke with the commissioner about his current plan for using current current resources and his plans for shifting some of the stuff with Long Creek to housing and stuff, and how different or why not wait and see how his plan works over the next year or two before moving forward with another bill and another law? Why, let's take what he's working on now rather than doing it, or how will they complement each other?
Yep. Well, thank you, Representative Rudnicki, for your question. It's always good to see you. And anytime you'd like to come visit in the Education Committee, we'd welcome you there.
I can't bring treats though.
Well, you shouldn't make that a prohibitive factor from your coming to visit us. But I have spoken extensively with the Commissioner of Corrections, as well as Associate Commissioner Colin O'Neill, about their plan. I think I am fairly well versed and understand how they intend to move $6 million from the current budget at Long Creek to address at least 2 programs in the community, and also have additional money that roughly is about $1.5 million that would be available to contract with community-based agencies. And I see this bill as complementing their effort, not as supplanting or that one would wait for the other. There are parts of this bill that are not included in the commissioner's plan. Just for example, section 1, and that's not included. The other thing is in section 5, the planning for looking at other secure residential programs, that is not necessarily part of the commissioner's plan, although we have talked and there may be some crossover there. So I think that this bill allows us to go forward and address a number of issues in the juvenile justice system, and that it complements and can work right beside what is being offered by the commissioner. And the commissioner, again, is looking to take $6 million a year out of the Long Creek budget and staffing out of the Long Creek budget to try to develop more community-based alternatives. So I see that as a positive step, and I think that is in keeping with the task force report. And I think that these 2 bills, or this bill and his effort, complement each other.
Follow up, Madam Chair?
Yes, you may.
So if we're already looking at moving $6 million Adding an additional, in this bill, it would add an additional, well, add an additional $1.5 million from the general fund for the corrections part, and then an additional $500,000 out of Health and Human Services. And this committee really doesn't deal with the stuff for Health and Human Services. You know, is that, are we basically overstepping by looking at, you know, money out of that part of it as well?
I would say, give a definitive absolutely not. I don't think at all that this is an overstep or an overreach. In fact, I think it's a step, as I mentioned before, a step forward to try to intertwine the three different departments by having joint funding between the three. Clearly, this bill would go to the appropriations table, and it would be a decision of the appropriations committee in terms of how much funding and where the funding might go. But I actually think we should be seeing more bills and more initiatives where we're trying to get the different departments to cross-pollinate, to coordinate, and to share resources with one another, as opposed to continuing to silo resources and silo initiatives. So I don't think it's an overreach or an overstep by this committee to be looking at funding for the Department of Health and Human Services. And I would just say this bill was submitted last year, and the Department of Health and Human Services supported the additional funding that would go to them. And they were excited about having the opportunity to work with DOC on this initiative.
Next, I have Representative Morales.
Thank you, Madam Chair. Hello, Representative. Thank you for being here.
Good to see you, and congratulations on your recent appointment.
What was that? I'm sorry. What am I been appointed to that I don't know about?
Well, you were prominently noted in the Portland Press Herald yesterday for your appointment to the board of Northern Lights.
Oh, I see. Okay. Thank you very much.
Wait, I hope that didn't skip your attention.
Oh no, I've been very involved in that. I didn't read the paper.
Okay.
All right, I have a couple questions for you related to mental health and housing, particularly, and I don't remember exactly the figures, but I was hoping that you can enlighten our committee on the number of young people who are incarcerated in Maine who have mental health issues and then have significant housing issues. And if you could kind of expound on how that is a barrier to finding placement in the community for them.
Yep. Well, thank you. Well, the report that was completed by the Juvenile Justice Committee showed that a significant portion, and I don't have the percentage right before me right now, but well over half had mental health and/or substance use issues. When I was more involved with Long Creek, we estimated that almost 80% of the youth that were at Long Creek were involved with substance use in some way, shape, or form, either during the act that they committed that resulted in them going to Long Creek or just in general. So I think it's fair to say that the mental health needs and substance use needs of youth at Long Creek are significant and extensive. The thing that gets a little bit more difficult is then determining the placement in terms of what you need to do in the community to simultaneously address those issues, those mental health and substance use issues, and provide some level of security at the same time. I would say of the 26, and you'd have to ask the Department of Corrections to verify this more than myself, but there's probably, out of that 26, maybe half that may be able to be in the community today, tomorrow, or next week if there were an appropriate community setting. There may be another 10 to 15 that would need some type of residential program that was more secure and therapeutic at the same time. But I'm using kind of gross generalizations and not as aware of that population as people at DOC might be. And, clearly there are youth, of those 26, 25, 27 youth at Long Creek, a portion of those are simply detained. And, in our report, Representative Morales, that one of the things that we do not do well, or one of the things that we do poorly, is that we have youth that are detained that are staying there for longer periods of time than necessary because they're not appropriate placements within the community, and they do not pose a threat to themselves or to the community. So back to Representative Rudnicki's question, that $2 million, if that were appropriated almost immediately, we could work to develop those placements in the community for those youth that are being detained there for longer periods of time, simply because there's no other appropriate placement in the community, and they are of no risk to themselves or the community. Again, there are another portion of those youth that are not going to be captured in that funding or in those programs because they're going to need a more secure setting.
Right, thank you for that. Could I have a follow-up, Madam Chair?
Yes.
And to that point, that's the most, there's a lot of troubling things about the young people who are incarcerated that I know we all feel because we all care so deeply about them. But the troubling thing about the low risk, the fact that they are not a risk to public safety, but there's no place to go. And don't you believe, do you think that the reason why, the Department of Corrections is the first department to respond is because that's what we fund? We don't have something in the community, right? Because we don't fund it. Isn't that sort of what it comes down to?
Not necessarily. I just think we need to make a distinction between those youth that, for lack of a better word, commit an offense that then puts them into the juvenile justice, criminal justice system. Those youth may have mental health issues, substance use issues, educational issues, and all kinds of other things. But once they've committed an offense and get into the criminal justice system, that system plays out with the judge making a decision about where you're committed to, where you're placed, and those things. That's different than a youth that may be experiencing some type of mental health issue in their school or some other placement in the community, and the Department of Human Services can respond and should be responding, and those community-based services should be responding to that family and to that youth. But that is outside of the juvenile justice and court system, which you're, very aware of. And that's why I think it's important as much as we possibly can to keep youth out of the juvenile justice system and out of the court system, because our ability to, quote, provide services, treat within the community is far greater. We have far more flexibility rather than when they get a probation officer and involved with the court system and judges making decisions about where their placement will be.
Well, thanks for that. I think probably maybe we disagree on focusing on what we've always done versus taking sort of a new approach to things, but I do appreciate your response. Thank you so much, Representative.
Okay. Next, I have Representative Lookner and then Representative Pickett.
Thank you, Madam Chair, and thank you again for your work on this, Representative Brennan.
I love your background, Representative Lookner. I know right where that is in Portland.
It's in my district. It's my claim to fame here. So let's see. My question: you talk a lot about, and I agree, the need for more, I guess less siloing between the departments, and kind of where I arrive on this, and I'm wondering your thoughts. Does there need to be some kind of a separate agency that is not DOC, that is not DHHS, that is not Department of Education, that looks after these youth? Because that's kind of where I end up on this. There needs to be some kind of a separate agency that DOC isn't doing it doesn't have the necessary resources, and DOE, DHHS, none of them are properly equipped for this specific population. Would you agree?
When you put it directly like that, the best I can say is I'm not sure, and probably I don't agree. Because again, I get worried about siloing youth into one particular department or to one particular area. Back to Representative Morales' question, one of the things that we struggle with, and this has improved, but we simultaneously have youth in the child welfare system who are also in the criminal justice system. And you have the involvement of both DHS and DOC. At one point, this was many years ago, there was a full-time child protective worker placed at Long Creek because over 20% of the youth at Long Creek were also in the child welfare system. So the difficulty we always have is how do you assist youth when they're in cross-system issues? And certainly having a youth in the criminal justice system and the child welfare system require both of those systems to be able to talk to each other and to speak to each other. And then at the same time, if the child has an IEP for special education, which is governed by a whole another set of principles, again, you're trying to deal with the child welfare system, the special education system, and the Department of Correction system. And I don't think Maine does a particularly a good job at that, but we're not any worse than most other states that struggle with trying to assist youth that span several different agencies at one time. Now, if you were to pull all those youth out and put them someplace else, I don't know where that someplace else would be, given how much federal law and other best practices govern what happens in an IEP situation, in a child welfare situation, and in a Department of Corrections court situation. So, Representative Lichtner, if you can divine that and figure that out and come up with a system to make, then yes, I'll be with you.
Yeah, it's a lot. And
if this bill leads us more in that direction, I'm even more fervent in trying to get it passed and move forward. But the great difficulty that we have is youth that are involved in multi parts of our system simultaneously.
Agreed. Thank you.
Representative Pickett.
Thank you, Madam Chair. I see in the participants that Commissioner Liberty is here. I have a question for him.
Great, thank you. Jeb, would you bring over the commissioner and the assistant commissioner or deputy commissioner, Mr. O'Neill?
Sorry, did you call on me?
Yes, thank you. Could you bring over Commissioner Liberty and Deputy Commissioner O'Neill?
Certainly.
Or Assistant Commissioner, I can't remember the term. Sorry about that.
They're on their way.
Thank you very much. Good morning, welcome. Good morning, thank you for being here. Oh, I guess good afternoon, right now.
Good afternoon, good to see you all.
You got another minute.
Good to see you, thank you for being here. Representative Pickett.
Thank you, Madam Chair. Commissioner, in your testimony of March 26th, you said, we're here today standing with the sponsor, with the advocates, and with all of those interested in focusing their attention on reducing the use of secure confinement by increasing the use of community supports. And so you also said afterwards there were some consideration of amendments to streamline the reporting requirements outlined in the bill. That being said, the program that you have been working on to meet many of the needs, if not all of the needs of what we're talking about in this bill, that particular program, you look in here in your testimony and you had some questions on 2, 4, and 5 and on 8, and 8 in particular being the funding, because the funding, as I recall, the funding for the program that you presented to us earlier was that funding was going to come within the existing budget of the Department of Corrections. Is that correct?
Yes, Representative, that's correct. That's one of the few areas that Representative Brennan and we disagree with.
Okay, so in that respect, going back to the fact that you've worked hand in hand with the sponsor, and it appears as though you folks are in pretty much agreement with what needs to be done and how it needs to be done. What is there outside of what you're planning to do that the bill calls for, or other people are talking about that they want to have happen, that you would not be able to provide?
Thank you, Representative. Thank you for that question. The areas of disagreement are concerned where there are a couple different areas in my testimony regarding to the consolidation of reporting rather than multiple agencies sort of deal. The recognition also, if you look at sections 6 and 7, it's important to note that currently the Maine Department of Corrections provides funding to 26 different nonprofits and providers in the community in prevention and treatment. And that equates to, and this is external to our plan that we've presented, we currently fund about $3.4 million in providing external community-based programming for our youth in detention and for transition out of the community. And it's important to note that, some of those organizations are Spurwink, Kennebec Behavioral Health, the Tri-County Multi-Systemic Therapy, Muskie Cooperative Agreement, Restorative Justice Project, Spurwink Diversion to Assets, Penquist. I mean, again, there are 26 of these organizations that we currently provide grant funding to and other support, again, to the tune of about $3.4 million. The additional $6 million of resources and positions and community-based housing would be on top of that. So we'd have more than $10 million going back into the community in an attempt to divert and to transition well back into the community for the youth that we're talking about.
Follow up, please. Commissioner, so the staff that would be involved in working with the youth from within the DOC themselves, you're accredited, correct?
Yes, we are. We're accredited by the American Correctional Association.
And I know there, from reading through a lot of the testimony last night, I know there was some concern about the certification or the accreditation, that you're not certified to do some of the work that is looking to be accomplished with these youth in the DOC. And so can you just speak to that a little bit? Why do you feel your accreditation, I'll get it right sooner or later, maybe. But anyways, would you agree that that is equally as well as the other people out here that would be able to do the same work that that you would like to do with these youth?
Yes, as you'd mentioned, we're accredited. And for those areas where we don't have the expertise, or we believe someone in the community can provide a better resource for the youth, we contract with them to provide that service. And as I said, we have 26 service providers now that provide those specialized services that we are unable to provide.
And so basically what you're saying then is you would be overseeing the program because it's the program you're putting together, but you would be also utilizing expertise from outside and inside the facility to work with these youth to make sure that they got what they absolutely need. Is that correct?
That's accurate, Representative.
Okay. And just one last question, if I may, please.
Yes, please.
Thank you. I know there's been a lot of talk about closing Long Creek. And there was one question again, I believe this morning, about timeline, about when is Long Creek going to be able to be closed down effectively. Just throwing out a hypothetical here, and it may not be so hypothetical. If you don't have Long Creek to house juveniles that do need to be in a detention facility, what is your plan? What is your plan if indeed Long Creek is going to be closed down at a certain point? What is your plan for the people, for the juveniles that do still need to be in a detention center, if you have one?
Thank you. So that is not my plan. My plan is to develop these community-based resources in diversion and in transition to assist the youth to transition or not come into the custody of the Maine Department of Corrections at Long Creek, and to monitor the investments that we've made, the now $10 million in the community, and see where those numbers lie over a period of time. That may be 6 months, that may be 9 months, and that'll allow us to re-examine the best steps forward. And that will mean, phase 2. Where do we take additional investments? Where do we place those monies? Where can the youth be served? For me, it's not about Long Creek, the structure, the building. It's only about providing the best service and reducing our reliance on incarceration for the youth. The discussion about that structure, that building, I think it confuses the issue. I think all of us just want to provide the best service and divert youth from incarceration.
So then, if I understand you right, then as you move through this and see how this is working out, and you're not beyond taking some of the budget for that facility and moving that into wherever it needs to be put to be able to help these youth. Is that correct?
Absolutely correct. That's my intention. My intention is to make an informed decision based upon the data and the feedback from the community-based advocates, and see where we can best place that money. But at this point, it's premature to decide that. If we have 6 months, 9 months worth of data, then we can move and make an informed decision and best serve the youth in the community.
Thank you, sir.
Thank you, sir.
Next, I have Representative Lookner. I thought I had Representative Newman. I have Representative Lookner next.
Madam Chair, thank you, Commissioner. So what's the population in Long Creek as of this morning?
Representative, the population in Long Creek currently sits at 26. 15 of those are committed and 11 of those are detained.
Okay, thank you. And there are still currently 170 DOC staff at the Long Creek facility.
Those are the positions that are authorized. Many of those are unfilled, as we had spoken, only using the staff that we need to fill those vacancies. And so there are times when we hold those, we do not fill them. And we're using those positions, as you know, to push into the community for funding and to take some of those positions and put them into the community-based housing.
Okay. Thank you for that. So can I just have a follow-up?
Yes.
Yeah. So what percentage of the young people in Long Creek need housing, right? Like could just be transitioned into housing if it were available?
If I may, Representative, I'll defer that question to Associate Commissioner O'Neill.
Sure. Yeah.
Thank you. It's a great question, and it really begs, to really define housing, right? Because our young people need more than just the bricks and mortar or being into a house. They also need the supports and supervision to be in a house as well. And so it's not just a question of that they're homeless, and if they had a place to go, that they would be transitioned right out of Long Creek. It really depends on the support and level of supervision that they need to transition out. Our current plan, we have a girls' residence that's outside of Long Creek opened. And we are planning to open up in the next couple of months a boys' residence. And, that will hold up to 8 residents. And right now we've identified at least 5 boys that could transition to that residence once that's open.
Great, thank you. And I guess I just have one more question, if I may.
Yes.
And this could go to either Associate Commissioner O'Neill or Commissioner Liberty. So where have, since the pandemic, I guess, like, we've released a lot of these young people who are formerly in Long Creek, where had they ended up, and what have their outcomes been like?
That's a great question. The youth that we've transitioned out that were committed or detained, most of them have transitioned back home with added supports. Recently within the last year, we brought in a big contract for a youth advocate program, and that provided additional support for these youth to be able to transition out of Long Creek. Also, the reduction of youth going into Long Creek has been significant. Twice a week, I get on with my staff. We review youth that are kind of potentially running the risk of being detained. And we really look at ensuring those youth present a public safety risk, an imminent public safety risk, before it's looked at as whether or not they need to be detained. And so that's really shifted and reduced the amount of youth being detained unnecessarily. So it's kind of at the front end, and then at the back end, that we've been able to really successfully reduce the number of youth at Long Creek, currently at Long Creek.
Thank you for that. Just to nail it down, just last question, I swear, if I may. So the outcomes for the kids, for the young people, have been released since the pandemic and are in their homes with additional supports. Generally, they've been okay.
Yeah, it's been a challenge because the supports that we rely on are also remote and not as face-to-face as they were pre-pandemic. So that's been a challenge for us. Really, we don't, the kids run the risk of coming back only with new criminal conduct. And so the youth that are transitioned out, they stay out. However, if there is a case where they've committed new criminal acts, we will potentially bring them back into the facility. And we have had a number of youth that's happened. But by and large, most of the youth have been able to stay out.
Fantastic. Thanks.
Representative Newman.
Thank you, Madam Chair. My question is, can somebody give me a ballpark percentage of the services being proposed in this legislation? How much of it is overlapped to the proposed services that Commissioner Liberty was talking about shifting out of Long Creek?
Thank you, Representative. Colin, would you take that, please, to see what the overlap is with OCFS?
I guess the services and the agencies in which we contract out with are often, I'd say, over half to 3/4 of the agencies are also agencies that serve youth being served by the Office of Children and Family Services. So there's significant overlap with providers that we contract with. I guess that's the best way to answer that question, in the sense that money that we would get would go towards, or money that we're using are going towards those community providers that often serve youth in other systems as well.
Follow up, please.
Yes.
Well, what I was really getting at is, if, say, 50 to 70% of the services, adding the housing and everything else, was already being proposed with the shift out of Long Creek. With the $1.5 million that they're proposing for this particular piece of legislation, would the money shifting out of Long Creek cover that without having to add new funding? Because I'm a person who doesn't like throwing money at something and saying, yes, it's going to solve the problem until I can see what's going on.
Commissioner or Associate Commissioner, did you have an answer to that?
I guess I kind of missed the question, but I think that the proposal we're making is, to reinvest those $6 million into the community. And again, I need to make an informed decision. I need the data over a period of time to see just to see if that's adequate or not. And if it's not adequate, I'll be reinvesting more monies from the Long Creek operation back into the community. We'll continue that process until the needs are met for the youth in Maine.
So
I would add to that is that, clearly our $3.4 million investment has yielded some great outcomes so far. It's worked towards reducing the number of youth at Long Creek. And additions to that, we believe will also have a impact on reducing the number of youth in our system as well. Again, it's as the commissioner says, we like to kind of go slow, look at the impact and where the needs are, and let the data drive where we need to spend some of that money and go from there.
Thank you. I have 3 questions, and I'll try to put them in an order that makes sense. My first question is around specifically the 26 youth that remain, 15 committed youth, 11 detained youth. Obviously, you guys have done a lot of work, you and your team, to get the population down, which means getting youth out of that facility and back in their communities. And you just answered and really illuminated for me some of how that happens, which is the contract with YAP in making sure that folks have additional support, to return home, et cetera. So my question is sort of, we know that there are a handful of youth that are likely always going to need to be in a secure facility, right? And we're talking about the youth that are doing time for murder, manslaughter, etc. They need a place for long-term secure confinement. So how many would you say we're talking about of the 26 where we need that secure confinement? Not they can be in Barrow's house or, some other place that you're developing. The folks who need secure confinement.
Go ahead, Colin.
Okay, it's a great question. And I guess, there's currently, I think we need to separate the 2 populations out. Out of the 26, 15 are committed and 11 are detained. And I agree, I think, there always will be a need for secure confinement. And just how big really depends on what our other options are for those youth that come in. And so the way to look at that is looking at, out of those 15 youth, there's about 10 that really have significant correctional or criminal histories that are going to require kind of a significant period of time in secure confinement. What we get out of the community residences is the option to move youth that are committed immediately to those residents, or those youth that may have significant criminal histories we can shorten the length of stay in institutional secure confinement. So not all youth have to stay as long as they used to, because we have an alternative that is more normative and is in the community and is not locked up. So, but to answer your question, right now, I would say, we have about 5 out of that committed population that could go to that community residence today once we have it opened up.
Okay.
And it leaves about 10. And as you know, we have no committed girls at Long Creek. Because we were able to develop that option out in the community, that enabled those girls to be able to be out of the facility.
Thank you. So we have 10 youth that either for the public safety or their safety, they need secure confinement. Would you say that's probably a number that has been consistent?
That's a great question. I mean, our numbers over the years have definitely, if you look at the number of youth that have been arrested, have been charged.
I get all of that. I want to try to move you along. I understand all of that. And let me just be very clear about what my question is. I understand that at the height, we were talking about 250 youth. My question is very specific: murder, manslaughter, the kids that need secure confinement. Average 10, 15, 20, 200. Can you give me an answer to that?
On the committed side, I'd say, anywhere between 10 and 20, depending on that. And then on the detained side, similar.
Thank you. So 10 and 20 on the committed side, but currently 10. So let's just say, for these purposes, because I think it is important and it does matter, and Commissioner Liberty, I understand what you're saying, that also thinking about cost and building, I think what you said, it confuses the matter. I don't have the luxury, and neither do any of these elected officials, to not care about cost and building and money, because that's also what we're elected to do. So I just want to be clear about that. I have to think about that. I am going to think about it, because all of my neighbors are paying taxes that are paying for it. And that's what they've elected me to do. So I have to keep these together. So if we're talking about 10 kids, 10 young people that right now absolutely need secure confinement, let's just put those over there for a second. Let's know that we agree they need it. So that means that we have 16 youth, and that you've worked hard to get folks out, but we've got 16 youth that are left that don't really need this secure like lockdown, right? We agree on that right now. What do we know about those 16 youth that we can't get them out of this facility? So that's the information that I'm going to be looking for the next work session. A de-identified list of, 10 of them have substance use disorder, 10 of them can't go home, 10 of them, whatever that looks like, because we have a real opportunity right now. Our population is so low that maybe there are answers to what we need represented in what is left, as you've worked so hard to get the youth out. Is my train of thought landing with you, first of all?
Yes, I understand that it makes sense to do a detailed analysis of why they're there, what the circumstances are, what they need for services. I agree.
Yep. Thank you. So that might lead us to what's missing in the community, right? Again, just because we get this all the time, still knowing that there are these 10 kids who need to be locked up, right? That's the premise that we're having this conversation based on. I'd love that de-identified information so that this committee has more sort of guidance as we take the next step, which leads me to our process. And this is my question. My second question is about our process. I'm a little unsure of where we are, right? Commissioner, you brought to us a strategic plan. We also have this bill, so we're doing this process together. You brought a strategic plan. We know that you've also told us that the governor at some point is going to give us more information in a change package. How can we bring these things together? How can we be doing all of these three things at the same time? You might understand that it makes me a little nervous that we're moving forward with legislation, but we're kind of waiting for the change package because we know something's coming from the administration. Commissioner, can you give us more information about the timing of that, or how that could help us and how we could work together around that?
I have no idea what the process is with the legislature and the budgeting and when that process will happen. It seems to be ever evolving. And so I'm not certain what the procedure will be for the budgeting and all of that. That's it's a mystery to me sometimes, what happens legislatively and all of that. So I don't have a time frame for you. I do not. I'll tell you this, we continue to work together, the co-chairs of the Juvenile Justice Task Force. I work with Representative Brennan often. Colin's involved, as is Jill Ward and Mark Solar. We are very close to signing a contract for the lease of the property of Auburn. Steps is open, as you're aware. We expect that Bearings will be open in the next 60 days or so, working through all of that with personnel. I will say that your previous comment related to the cost of Long Creek and all of that, the cost is really positions. There's no mortgage on that place. It's free. That doesn't cost us anything at this point. I would say that if we're seeking savings as a result of closing Long Creek, that may be a myth, because if we have to build secure facilities elsewhere in the state, that's going to cost $10 to $12 to $15 million to build those facilities. The one we're building in down east right now is an $8 million project, as you're aware. There is no savings in the walking away from a particular structure at this time. The real cost is personnel. It's the personnel to staff what we're doing. That's where the expense is. So if we think we're going to, if there's a belief that we close Long Creek and we save 18 million, there's no savings there, because those resources will be reinvested back in the community either way. And if we have to build secure facilities for these 10 to 20 youth in multiple locations, we lose the economies of scale, and it's expensive. So I think that if people are searching for savings as a result of the direction that we're all heading in, community-based sort of work, there is no savings there. There's no windfall there. And I think that that may be a myth to believe we close Long Creek, save 18 million, and that's, in my estimation, that is not the case.
So your answer to my second question was you're not working with the administration on the timing of when we'll get the governor's change package.
That I am not involved in that. That's a DAF's governor's office. How they're maneuvering that, I do not know.
So is anybody else concerned that the legislature is working on Long Creek, the commissioner and his team is working on Long Creek, and the governor's office is working on Long Creek, and everybody's sort of doing it on their own? Nobody has to answer that question. I have that concern. My third question is just, again, about the property. I heard you say it doesn't cost us anything. I find that that's impossible for me to think is true. So those are my questions. I'd like that information for the work session. Other questions? Representative Brennan, I see your hand up. I hesitate. You had a lot of time.
I agree, Representative Warren, and if you would just indulge me one more time, I would appreciate it. And I know this is a frightening thing for me to say to you, but I've been thinking the same thing that you did. And if I could just clarify 2 quick points and answer a question that Representative Rudnicki, Representative Newman, and Representative Morales raised before. But if you recall last March when I submitted this bill, it called for a $3.5 million appropriation. And that 3.5 million appropriation, in my mind, was directed at those 10 to 11 youth that are detained at Long Creek and are there because we didn't have appropriate placements in the community. And if you look at the 2 million that is being asked for here, combined with the roughly 1.5 that the department is taking from the current Long Creek budget to put in community-based services, it matches up with the $3.5 million. But that 3.5, 2.5, however amount of money, I would concur with you, should be immediately directed at those 11 youth that are detained. They're not a threat to the community, but we just need to develop those community placements. And if we do that simultaneously with doing the work to develop these 2 to 4 residential programs, all of a sudden the population at Long Creek is non-existent.
Thank you, Representative. Other questions? Obviously, we're not going to take a vote on this bill today because we have a lot of questions. Representative Pickett.
Yes, thank you, Madam Chair. Yeah, I agree. I don't think we're in a position right now to move this forward. And I do like the idea of what the DOC is doing. I support what they're doing. I just think we've got to do a little more digging and get a few more answers to some questions. But we need to get the people that are working on this, we need to bring them together so that we can actually do much like we did on the 2 bills prior to this. Because I believe if we are going to pass any legislation out of a committee, we need to be able to do the very best job we can do with the very most information we can get, think through it, and then put it together in a way that it has its best chance to be successful. If we don't do that, we just put the burden on the next people coming in that are going to have to try to fix what we didn't do properly. So I want to do this right. I want to do it in a way that we can all agree on, if at all possible. And the one thing I would stress for myself is this. The thing we need to try to do, and I think it's imperative, we need to try to do this within the confine of the monies we have right now and not any new revenue. And we just cannot go out and put new revenue into it. That's going to mean more taxation for the citizens in my district, your district, and everyone else's. I can't put that burden on them right now after a pandemic and without knowing exactly where we're headed with the budget we just passed and all of that. I can't do that to my constituents. I won't do that to my constituents. So if we were to go and put revenue in here that is not already there, I cannot and will not vote for that. I don't want that to happen. I want to help these youth. I want to do it in a proper way. And so I think we really need to take and put some more time into it. The people involved here have got to get together and really come up with, we need answers to some of those questions. And we need to know what the other parts of the 3 parties that you talked about, Representative Warren, what they're thinking and how they can all mesh this in together and make it work. And again, Commissioner Liberty, I am in full support of what you're trying to do. And if I want to make it work, I just want to make it work in a way that we're not going to have to be back trying to fix it later. So thank you very much.
Thank you.
Representative Rudnicki.
Would it be appropriate to carry this over and give the commissioner, give the governor, everybody a chance to work this together before we try just tabling it and, you know, hoping in a month or whatever? Wouldn't it be more appropriate to hold it over until next, the next regular session, and give them a chance to work together before we try to do this, because there is so much work that they still need to do among themselves.
I like your thinking there, Representative. And my only worry is we have a real opportunity right now because of the low population. And I really do worry that if we don't sort of strike while the iron is hot, next year things could look very different. As we all know, the courts are preparing to reopen, right? And if we don't sort of put some guardrails, I think the same highway is open to a very expensive proposal facility endeavor for the state of Maine. Do you see what I'm saying? Does that?
I do, but if we don't give them a chance right now to work together, because if we say, oh, they got to come back in a month, well, we all know with everything going on, it takes longer than that. I mean, we've been 3 months and we haven't put out many bills. So what I'm saying is give them a chance. I mean, we know, or maybe it's a letter directing the governor's office, directing the commissioner's office, everybody to work together. Maybe that's the appropriate course for this committee to take at this time, a letter directing them to do that, so that we're moving in that right direction and then bringing it back, even if we bring it back in 6 months. But doing that, getting a letter, getting it a directive from this committee versus trying to do something different.
I hear you. Commissioner, what are your thoughts about that?
That sounds good to me. We are aggressively engaged in this work. We're determined to do it. We're aligned with Representative Brennan, with the co-chairs, with the task force. This is the direction we're heading, and we're going to be successful. And I'm certain you'll be pleased with the direction that we're heading in. I have a question regarding just some clarification on the analysis of the current population. Would this be something we present to the whole committee? Would it be something that we can present in a group setting to leadership so we can have detailed conversations about each one of these, or we just like a document provided to you?
That's a really great question. Thank you for asking. No identifying information at all.
Right.
Extremely de-identified, and definitely something that whatever you need to do so that it can be reported to this full committee and to the public, because I think that's really important and why we are doing this. Representative Rudnicki, I don't want to not answer your question, because I think everybody's questions deserve an answer. And so I'm not trying to skirt your question. Sometimes it's just me trying to figure out what are the right words to say without being disrespectful to anyone. And I'm not saying I would be disrespectful to you. I just mean in general, we spent all of this time on a task force and a lot of money. And why aren't these parties already working together? And so that's my frustration. I'm not prepared to carry it over. I'm frustrated that we last year, but because of the pandemic, I understand it, all of the momentum we had built by spending all of those hours as part of a task force, which matters, right? Which matters to all of us when you put your work into something. I want the governor's office and the commissioner, I want them to be working together and bringing this information to us. And I don't think that that's too much to expect. So I'm not in favor of a carryover, because then next year what we'll hear is that study's 2 years old. That study's 2 years old. We shouldn't be using that. And there was a serious amount of money spent on hiring the Children's Law Foundation in DC to be here and to work with all of us. So I hope I answered your question. I may be the only one who feels that way, but I did not want to skirt your question. I have Representative Pickett and then Senator DeChambeau.
Yes, thank you, Madam Chair. A couple things. I really think we need to, if we don't have a definitive answer right now, if we just have, I think we can, or we may be able to, or whatever. I think we really need to have an answer as to whether this committee, who has no oversight over DHHS or education, can through legislation put in there, if we went that way, could put in there monies going out to those two agencies. Or I just, that part there bothers me a little bit. I just want some clarification on that. That's all for the next work session on that, how that would work and where that money would be coming from. So I know that it's all money within the structure of what we already have, nothing, no new revenue. The second thing is, I agree with the fact that I would like to see this, if at all possible, be able to be dealt with now, because I do agree with the same thing. We've worked on this last year. We put a lot of work in that. There's been a lot of work by the sponsor as well as everyone else that's involved. We got to just get those people together, have them talking, working it. And what's at stake here is, if we really here are talking about making our state a better place for our juveniles, all of our juveniles, regardless of who they are, to be able to have a better transfer back into the society, and have a better place to, if they do have to be detained, have a place where they can be detained and have their needs met. If that is really on our minds right now, then it should be on our minds in a way we want to get it done now, and not keep putting it off and putting it off and putting it off. I don't know if it can be done, but if we're going to do it and that is our goal, we really need to keep moving forward and trying to see if we can get something done. That's my opinion on this.
Thank you, Representative. Anybody interested in making, a motion to table? Representative Rudnicki. Oops, you're muted.
I don't really want to table at this point, because I still feel, and I agree, we need to move forward with this. But if we table, it's just another slowdown. I think if we set a date certain to come back and, get a report back at that point. So to see what the to see what the commissioner, that he's done to this point. If it's 3 months from now, if it's 6 months from now, we want to report back, who have you worked with, what you done, what's going on, where we're at. Every time we table another bill, we're just piling work for later on. But
How
this
about
way, if we have a
next
date certain and a letter,
Yeah, how about
instructions.
next week? How about we table till Friday? What do you think
Well-
about that? I'm not making a motion, I'm just asking you.
But how much can you get done? I mean, I don't think that another week is going to give us any more answers until they start the process and do what they're going to do. That's why I think if we look at just another week, I mean, we're like spinning our wheels here and not really getting a whole lot accomplished as far as what I can see. So I think if we give them, a date certain, say 3 months from now, come back with a, I want to, know what the governor and the commissioner has worked together, what they've produced to this point, what the data shows, where we're at, because it takes time to do all these steps.
Yeah, Representative, I hear you, but I'll tell you right now, in 3 months, I'm gonna be sitting at camp. I am not gonna be doing this. So, although I really love all of you. So I'm gonna really suggest that we do something a lot earlier than that. We don't have that kind of time. And I'm sorry if 1 week isn't enough time. We have had a long time, and it shouldn't be hard. Commissioner Liberty, can you get together with the governor's office in a week and get us this information and be back by next Friday?
Madam Chair, what are you seeking for information? Are you talking about the change package or the supplemental budget, all of that process? Is that what you're talking about for information?
Yes, so we have we have a bill that we're talking about right now. You have a strategic plan and the governor's doing a change package. And each of those things are sort of, and now we're gonna have another bill coming. So we need to figure out where are they the same and where are they different? And a place where we could start is you, the commissioner, being on the same page with the executive branch.
I am on the same page with the executive branch. We are perfectly aligned.
Okay, that's different than what I heard before.
No, what I said was I'm not sure of the process. I think even the legislature had a change in process over the last couple of weeks about how they're doing the budget, how that all works. And that's more of a systemic piece. I'm not sure that it's localized just to DOC. What are all of the other, what's the entire budget process look like? I'm not certain of that. I'm not certain of timeframes. I'm not certain that anybody is quite there yet. I don't know. That's more, for me, that's more of a legislative, governor's office to determine just exactly what the process looks like and what the timeframes are. I'm not certain of that, but there are people that in the executive that are, I'm certain, and same with leadership at the legislature are negotiating, discussing that. That's all I said. We are perfectly aligned, and I think that the momentum of the Juvenile Justice Task Force continues. This is not, we're not treading water. We've made significant movement in the plan, in the reinvestment in the community, in the reduction of population at Long Creek. We've made significant movement, and we continue the momentum of the work that we're doing with the youth. So it has not stalled, and it will not stall.
Okay, thank you. Senator DeChambeau, excuse me. I had Representative Lookner and then Senator DeChambeau.
Thank you, Representative Warren. I will defer to the senator to come back to me.
Thank you. Senator DeChambeau.
Thank you, Representative Lookner. I just have a bunch of things here, but I'm going to put it in perspective, I guess. This is obviously a work in progress. I don't know, Representative Warren, if you're even satisfied with this bill, and you don't have to answer that. I've heard the commissioner say, and you mentioned that a lot of money has been invested in people from Washington coming up, being consulted, having committee meetings. I was involved. But I just heard a few days ago the commissioner telling me that he is still in ongoing discussions with Mr. Sola, who came from Washington. This is somewhat fluid in the last 3 months, where the funding was coming, who's involved. This latest proposed amendment, rather than $1.5 million going to corrections, is $1 million in corrections was the amendment, 500,000 to DOE and 500,000 to DHHS. That's a result of discussions and having this collaborative effort, or almost a hybrid another department dealing with juveniles, which it should have. And because DHS and DOE for many, many years did not get involved in corrections or juveniles. Once they were locked up, that was it. The thinking has changed dramatically in the last decade. This is ongoing. I was surprised, Representative Warren, when you were not in favor of a carryover, that the courts will be opening up and the face of Long Creek will change. That led me to think that, did you suspect that instead of 26, we'll be talking about 126 next year? I'm not sure. So to go fast now and close it when in fact there are untried juveniles, which I don't even think that is true. I'd like to know that. I'm sure if there are some in the pipeline who have been arrested and waiting for court sentencing, that the judges will take them over adults and move them on. Don't know that for a fact. But there are so many, we said the word silos, but there's a bridge now. There's more of a bridge. And I really believe we would get a better picture and do a better piece of legislation if we did carry it over. So that's my position right now. And I've kept quiet this whole time just to keep listening. But I don't feel we're ready right now, not we as a legislature. That, you know, this is ongoing and this is fluid. We may have more than 27, and that's a different ball game right there. So I would like it to proceed in that level with the commissioner and Representative Brennan, and hear a better story as a carryover. That's it. Thank you.
Representative Lookner.
Thank you, Madam Chair. So we do have other bills coming up pertaining to this issue. That's a very important issue. And I think, you know, folks have been working on this for a lot longer time than me. Agree that we should have some kind of movement on this. With that said, you know, I don't think this committee right now has the full picture, and I would like to move to table.
So we don't have a second, it sounds like, but I think we're moving in that direction. Representative Lookner, may I stop right there and hear from Representative Brennan quickly and come back to you?
Yeah.
Since we don't have a second. If we had a second, obviously there would be no discussion. Representative Brennan.
Thank you, Representative Warren. I appreciate the comments of Representative Rudnicki and Senator DeChambeau. I think if you were to table this for 2 weeks, I think we would be able to come, the commissioner, myself, and other interested parties could come back together with the information about the 26 youth that you asked for an analysis for at Long Creek now, and that we could make an effort, if not be successful, in lining up this bill with the change package. And so that would present to the committee how this bill and the change package would go forward simultaneously in terms of complementing each other. And it would give you the information on the 26 youth who are currently at Long Creek.
Thank you for that. Thoughts? Representative Pickett.
Thank you, Madam Chair. So what I'm hearing is that the Representative Brennan is saying that he feels within a couple of weeks that they can get the information that he believes we may be able to do something to move this bill forward. That being said, you know, I'm not in objection to that whatsoever. So I think if someone were to put a motion out to table for 2 weeks, then at least we could take another look at it then. And I would think that if we took a look at it then and we still are in the same quagmire we are in right now, then we could at that point there decide that, you know what, maybe it is something that needs a lot more time and maybe carried over at that time, but at least give the sponsor a chance to see if they can pull this together, like I think we would try to do with any other sponsor that came in on a bill that we were trying to move on.
Thank you, Representative. Representative Lookner.
I don't have a question right now.
Did you want to make a motion?
I'll make a motion to table.
Seconded.
All those in favor? Deb will call the roll.
Please turn your video on and unmute for roll call vote. Representative Warren,
Yes.
Representative Morales is absent. Representative Reckitt,
Yes.
Representative Sharp is absent. Representative Lookner,
Yes.
Representative Pickett,
Yes.
Representative Costain is absent. Representative Rudnicki,
No.
Representative Newman.
Yes.
Pardon?
Yes.
Thank you. Representative Pluker,
Yes.
Senator Lawrence is absent. Senator Seaway is absent. Senator DeChambeau.
Yes.
That's 7 yes, 1 no, and 5 absent.
Wonderful. Thank you, Deb. Thank you, everyone, for your
Chair.
work on
Madam
this.
Chair? Madam
Yes.
Chair, I just wanted to let you know, as you probably have noticed,
Yeah.
Representative Costain is no longer in Zoom with us. I'm not sure exactly what happened, but apparently he must have to go outside for something or whatever, but he fell about a half hour ago and he's at the hospital. He thinks he may have dislocated his shoulder or even broken his shoulder blade.
Oh,
So just want to let you know that so you could be thinking of it.
oh, terrible.
Thank you for that. I did just get that message from him, so we will definitely be thinking of him. Okay, so it is 1 o'clock and we have a public hearing starting in 3 minutes, but obviously we've got to take a break. So Senator, what's your thinking? You guys are there. Need a half an hour or you need 20 minutes?
1:30. 1:30.
Yeah, we could probably be back 1:30.
Okay. Thank you, everyone. See you at 1:30.
got 7.
Yep, we're ready.
Okay.
We're ready.
Well, I'm here, but
Okay.
I don't think I.
Ask her to introduce herself while she's eating.
Well,
Get that potato chip bag out of the way so we can't see it.
huh?
It's right in front of your camera. Get that potato chip bag out of the way.
You can't see it.
I know, but when you put it on, you will.
Hello? Oh, why? I'm still Deb Fahey? That was a mistake.
I'll fix that, Senator.
Every time I try to put on a scarf, I go, where's Just Faye when I need her?
I know, she's so good at it.
I know, really.
Hello there.
Hello.
I'm waiting for Representative Renecki, and she's there. Good. All right. We have a quorum. I hate eating fast, you guys. Monday through Friday is difficult. So thank you, Representative Warren, for chairing the meeting this morning and part of this afternoon. It's a long one. We are now in the afternoon. We have a public hearing on 2 bills. And I'm not sure if we have new people, but let's take a moment to introduce ourselves for the public, because I believe there are a number of people that might want to testify on these new bills. I will call on Representative Warren.
Thank you, Madam Chair. Hi, everyone. I'm Charlotte Warren, and I represent Hollowell, Manchester, and West Gardner in the House.
And Representative Pickett.
Thank you, Madam Chair. My name is Dick Pickett, and I represent District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru.
Thank you. Representative Reckitt.
Good afternoon. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Representative Renecki.
Good afternoon. I'm Shelley Rudnicki. I represent House District 108, which is Fairfield, Mercer, and Smithfield. And I am once again here under protest because we voted to adjourn last Tuesday that our work was done. Thank you.
Representative Lookner.
Good afternoon. I'm Grayson Lookner, District 37, which is part of Portland, out around the jet port.
Thank you. Representative Pluker.
Thank you very much. I represent House District 95, which is Hope, Warren, Appleton, and part of Union.
Thanks. And Representative Newman.
Yes, I'm Dan Newman, District 76, which is Belgrade, Rome, Mount Vernon, Fayette, Vienna, and Wayne.
And joining us and still with us, our policy analyst, Jane Orbiton. Thank you, Jane. And our committee clerk, Deb Fahey, is with us. Thank you. Again, for those of you who are new, where Miss Fahey is in the square, you'll see the LD that we are looking at right now. We have another LD, 782 following it. I should introduce myself. I am Senator Susan DeChambeau, and I represent District 32, which is Dayton, Alfred, Arundel, Lyman, Kennebunk-Port, and my hometown of Biddeford. Just briefly, I want to say that obviously we are assembled today electronically. And before I get started, I want to share some brief information on how it's being conducted. This is being live streamed on the YouTube channel. This means that anyone who is a participant in the meeting can be seen and heard if their microphone is unmuted. People on the Zoom meeting waiting to testify cannot be seen or heard until they are called upon to speak. Before each bill is presented, I will ask the public, or I should say after it's presented, I will ask the public to raise your hand if you wish to speak. The way we conduct our meetings, I will call after the sponsor submits or reads the testimony for the bill. The committee members may ask questions of that sponsor. I will then recognize any co-sponsors or other legislators who wish to speak. I will then ask all those from the public who wish to offer testimony in support, followed by those who wish to offer testimony in opposition, to raise your hand. And third is anyone who wishes to speak neither for nor against the bill to offer your comments. You will have 3 minutes to speak. And now I will, and we have a clock, I believe. And now I will open the hearing on LD 769. And before I begin, Representative Warren, I saw your email earlier this morning and I don't see it now. The one that you asked, there were 3 people that could testify after Representative Stover submits the bill.
I'll resend it to you. It was a request from the administration. I'll send it to you.
Thank you. Thank you very much. So LD 769, an act to increase the availability of mental health services for a defendant who has been found incompetent to stand trial. We have with us Representative Stover. Welcome.
Thank you. Thank you, Senator DeChambeau, Representative Warren, and members of the Committee on Criminal Justice and Public Safety. My name is Holly Stover, and I represent House District 89, including the towns of Boothbay, Boothbay Harbor, Southport, West Port Island, and part of South Bristol. Thank you for the opportunity to appear before you today to introduce LD 769, an act to increase the availability of mental health services for a defendant who has been found incompetent to stand trial. This is a DHHS bill, and at this time, I would like to turn this over to Dr. Deborah Bader from DHHS Office of Behavioral Health to walk us through the bill. Thank you.
I'm bringing Deborah Bader over.
And Madam Chair, I just resent you the email, and Dr. Bader is the first one on the list. And hello, Representative Stover. Thank you for being here.
Thank you, Madam Chair.
Hi, can you hear me okay?
Yes, good afternoon. Thank you for being here.
Thank you for having me. Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Dr. Deborah Bader, board certified forensic psychologist and clinical director for the Office of Behavioral Health in the Department of Health and Human Services. I'm here today to introduce and speak in strong support of LD 769. And the department thanks Representative Stover for introducing this bill on our behalf. Defendants found incompetent to stand trial, or IST, and found to be restorable to competence by the court, who exhibit highly aggressive and predatory violence to staff and patients at Riverview Psychiatric Center, are very difficult to behaviorally manage and therefore clinically treat. Given their relatively long stays and the high staffing requirements to safely manage their care, admitting these defendants often places on hold other forensic and civil clients needing an admission to Riverview. The ripple effect of admitting defendants with highly dangerous behaviors to Riverview include greater at-risk patient mixes, staff shortages due to injury, civil unit staffing disruptions, and special care unit bed vacancies due to the fact that IST clients with highly dangerous behaviors need intensive staffing and low patient interaction. The number of defendants found IST by the court and referred to state psychiatric facilities represent a relatively small number of defendants overall. For example, 57 defendants were found IST in 2018. Between 2015 and 2018, there were 345 documented incidents of verbal or physical aggression against either staff or patients, property destruction, self-injury, and attempted elopement perpetrated by 40 separate IST patients. That relatively small number of IST patients highlights the fact that a low number of patients with dangerous behaviors can cause significant harm. A gap in our current competence restoration services is the inability to both keep the inpatient admissions pipeline open and safely manage defendants with highly dangerous behaviors. Several other states have allowed defendants with highly dangerous behaviors found IST to be restored to competence either in jail or on a specialty mental health competence restoration unit within an incarcerated setting. The Intensive Mental Health Unit, or the IMHU, at the Maine State Prison is a unit separated from the general population and which aligns with the care provided at Riverview in that they employ a multidisciplinary team of providers, including a psychiatrist, 2 psychologists, a nurse, a unit coordinator, behavioral health technicians, and an intensive case manager to facilitate community reintegration. This bill would fill the gap in competence restoration services in Maine by allowing for the placement of pretrial defendants found IST with behaviors deemed too dangerous for placement at the state hospitals to be placed at the IMHU for competence restoration and treatment. This bill envisions a multi-directional option where individuals with behaviors that cannot be safely managed at Riverview can receive care and competence restoration at the IMHU until their behaviors are addressed to a point where they can be safely reintegrated into the milieu at Riverview. It is proposed that placing an IST defendant at the IMHU would both have a judicial safeguard and require a clinical recommendation. Having a fully functioning, multi-directional continuum of care for defendants found IST by the court would significantly assist in diverting defendants from longer jail stays, ensuring treatment, and improving safety. Thank you for your time and attention. Dr. Matt Davis and Superintendent Rod Bouffard will also be testifying to this bill from their perspectives at Riverview. I would be happy to answer any questions you have and to make myself and other team members available for questions at the work session. Thank you.
Hi all, can you hear me okay?
Yes, we can. Hold on one second, Dr. Davis. Good to see you. Thank you for being here. Representative Reckitt, did you have a question for Ms. Bader? For Dr. Bader, excuse me.
Yes, I did, if I could. Dr. Bader, you probably were not aware that I was in the committee hearing yesterday with Judiciary that was talking about this very topic. And I'm having flashbacks of what was said there. And my question is, do you think that this legislation would eliminate the problem that was being discussed yesterday about the people who are incompetent to stand trial and where they could be placed? There was discussion about Riverview and Dorothea Dix as the only places they could go. This would provide a third alternative. Is that what you're saying?
This would provide a third alternative, but for a very small number of defendants. In fact, what we're really targeting are defendants that are too difficult to manage at Riverview or Dorothea Dix. And in fact, currently, all highly dangerous IST defendants go to Riverview because they're the ones that have a physical plant that can, struggle, frankly, to manage, dangerous defendants. And, even with their valiant struggles, there are still a lot of staff injury and patient injuries due to these highly dangerous patients. So yes, in fact, this bill would allow the small number of dangerous defendants to be placed at the IMHU until such time as their behavior stabilized and they can be reintegrated into the milieu at Riverview.
Thank you. Nice to know I was listening yesterday. And my brain has not entirely died. Thank you so much.
Any other questions of Dr. Bader? Dr. Bader, and I don't see, I'll recognize Representative Pluker. Go right ahead.
Thank you, Madam Chair. I was just wondering to what degree have you coordinated with the DOC on this?
Very closely. They are, we've worked very closely with them on fashioning this bill.
And I saw under section 2, it says the commissioner may terminate the placement of a defendant except pursuant to the section. So it sounds like that when we say commissioner, they're referring to the HHS commissioner. So does the DOC commissioner have any input? What's their role and say around acceptance or moving on of patients?
Well, they would have to accept the patient. They would, you know, based on their bed availability and other factors, they would have to accept the patient. And then it would be a bi-directional process so that once they were if they were accepted and once they were at the IMHU, there's a lot of communication. Riverview staff would assist them with competence restoration programming and training their staff around competence restoration and monitoring the process such that if their behavior stabilizes, they can be returned to Riverview.
Thank you. And a follow-up question, Madam Chair?
Go right ahead.
Could you just let us know a little bit, what's the staffing like right now at Riverview? Are you short-staffed? Are you at full staffing? And then also maybe a little report on your beds, open beds, no open beds, that kind of situation.
I'm going to defer, if that's okay, that question to Dr. Davis and Superintendent Bouffard. I work for the Department of Health and Human Services in the Office of Behavioral Health. So okay. I'll defer to them to give you that information, if that's okay.
Thank you very much.
My question, Dr. Bader, is I've visited the IMHU at the prison, and these are individuals that aren't necessarily violent. They are mentally ill and do not function well in general population and do much better in an environment where there are staff members and professional staff members that can attend to their needs, also their medications. But when I heard your presentation, I heard of people that are waiting to be found competent, maybe after a violent act or what have you, as they're going to court. And I really don't see that population mixed with another population who have been found competent to stand trial and through no fault of their own have decompensated to a point where they need more intensive mental health. Is that something you've discussed? I see those almost halfway in and halfway out kind of individuals.
Thank you. I think what's important to recognize is that pretrial defendants are already allowed to be placed at the IMHU. So there are pretrial defendants at the IMHU who are there because they're considered too dangerous for Riverview, but who require a court-ordered evaluation and observation and treatment. So this would expand that population in only a very small way to include pretrial defendants found incompetent to stand trial. So they would be already joining a mix of patients who are there pretrial simply because of being transferred from other jails to the IMHU, but also pretrial defendants who are funneled there because they're too dangerous for Riverview and are requiring what we call a Title 15 evaluation or an evaluation to assist the court to have their case proceed through to disposition. Mm-hmm. So the mix, they would be in a mix that is, it would be a mix, but it is a mix of a variety of other pretrial defendants as well.
All right, thank you for that clarification. I have one other question, however. There are times, even within a correctional facility, someone decompensates so badly and difficult in mental health environment that they need mental health hospitalization. When's the last time Riverview accepted a transfer from the Main State Prison or the women's facility?
I'm going to have to, again, because I don't work right at Riverview, I'm going to have to defer that question to Superintendent Bouffard.
We'll get to you, Rod, okay, towards the end. You are number 3 in this environment, all right? Okay, thank you. Just please hold on to that. I don't want to lose track. Thank you, Dr. Bader. If there are any other questions, I will proceed to Dr. Matthew Davis. Welcome.
Thank you. Good afternoon, Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Dr. Matthew Davis. I'm a board certified psychiatrist and the clinical director at Riverview Psychiatric Center. I'm a distinguished fellow of the American Psychiatric Association and the president of the Maine Association of Psychiatric Physicians. Thank you for having me speak today in strong support of LD 769. My support really comes down to 2 reasons, which I'll detail momentarily, but those can be boiled down to be access to care and patient and staff safety. I don't believe I'll have an opportunity to go through my written testimony in its entirety, but I did want to call the committee's attention to some key points. Riverview functions as the hub of the mental health system in Maine. What happens at Riverview has ripple effects throughout the entire system. And that really is because we accept patients refer to us through every type of commitment mechanism, both civil and forensic, through the entire state. Patients are referred to us when there's a high index of suspicion that they have a major mental illness diagnosis that is causing them to engage in behaviors that are dangerous to themselves or others. And looking at instances in which an individual may be dangerous to others, there are really 3 major categories that would lead somebody to engage in interpersonal violence and aggression. These can be summarized as psychotic, impulsive, and predatory. Psychotic aggression and violence are undertaken by individuals with conditions such as schizophrenia. Impulsive violence and aggression are undertaken by individuals with conditions such as an impulse control disorder or bipolar disorder. The important thing is that with psychotic and impulsive violence and aggression, there is a treatable mental illness underlying those behaviors. On the other hand, with predatory violence and aggression, this is undertaken not due to a mental illness, but instead due to some type of secondary gain, for example, retaliation or intimidation. It's typically undertaken by individuals who have psychopathic or sociopathic personality traits. It is planned, calculated, methodical, and deliberate. It's not treatable. Research shows that it's best contained in a highly secure and structured environment. It's worth noting that at times, individuals with major mental illness diagnoses can engage in predatory violence. This is particularly important because we commonly see predatory aggression and violence perpetrated in our hospital in its most severe forms by individuals referred to us on an incompetent to stand trial or IST status. And this has 2 major effects at the hospital and for the entire mental health system. The first is access to care, which Dr. Bader described in her testimony, but I want to highlight a couple of key points. First is that when individuals refer to us on an IST status engage in this severe predatory violence, it's highly resource and personnel intensive. And that effectively means that we cannot operate the hospital at full capacity. We cannot fill every bed that we have. The second thing is that these individuals have much longer lengths of stay, on average almost twice as long as individuals refer to us on a civil commitment status, such as a blue paper. The ultimate effect is that these folks consume multiple beds for long periods of time, delaying our ability to admit other folks referred through other venues in the mental health system, whether emergency rooms, hospitals, or other venues in the corrections system. The second major issue is patient and staff safety. We have seen these individuals perpetrate severe acts of violence and aggression against other patients and staff that have led to serious negative outcomes. LD 769 helps address this challenge by allowing the Commissioner of Health and Human Services to have these individuals placed at the IMHU. We should note that we've looked at our own data over the past couple of years, and we've found that this applies to a very small number of individuals. Roughly 5 or so per year is what we would estimate. And we look to our neighboring state, New Hampshire, for example, as a state that deals with this significant challenge through this same type of mechanism. I'm happy to answer any questions that you may have, and I thank you very much for giving me the opportunity to speak today and for your consideration of this important piece of legislation. Superintendent Bouffard will detail the other major issue that the IST patients who engage in predatory violence pose for us, which is some specific examples of incidents of violence and aggression perpetrated against staff and other patients. Thank you.
If I may, Dr. Davis, how we proceed is I am asking any of the members who have specific questions for you. And I see Representative Warren.
Thank you, Madam Chair. Thank you, Dr. Davis. What is it about the IMHU that makes it a better fit for these patients?
That's a great question. It's a few different things. It's to some extent probably staffing ratios. To some extent, it's just the physical environment. I've toured the IMHU, and it's more highly structured and secure than we have at Riverview. We have certain licensing and other regulatory requirements that we have to abide by that the IMHU, for example, would not necessarily have to do. If I could just take a brief moment to talk about predatory aggression and violence, leading researchers, Dr. Stahl and Warburton, have published a lengthy book on violence in psychiatry, is actually the title of it, and they have found that containment in a highly secured and structured setting is really the only effective way of managing people who engage in these types of behaviors. It's not treatable. And the IMHU, for example, would be able to have a patient be confined to their room or cell and locked in a preventative, proactive way that we cannot do at Riverview. We have to abide by licensing and CMS regulations that are really very reactive, meaning we can't do anything until an act has already happened. IMHU, on the other hand, if they have a belief that a person will engage in an act, a violent or aggressive act, they have the ability to proactively contain the individual. They don't have those same sort of regulatory requirements that we do.
Mm.
Madam Chair, may I have a follow-up?
Yep, go right ahead, thank you.
So 3 things: staffing ratio, physical environment, and the licensing regulations at Riverview are different than what the licensing regulations are at the IMHU.
Correct.
So it leads me to, I mean, I'm sure it's not a surprise to anyone, you know, I came up in the sort of world of psychology and social work after we had decided as a society and a state and a country that we wouldn't lock up people strictly for mental health concerns, that we would put them in residential facilities. And so that's sort of my philosophical, you know, background, where I'm coming from, because of course, part of the work that we need to do is to put ourselves in the place of all of the Mainers that we're here to represent. And I think it's very different for a family when their loved one is struggling with mental illness, for their family member to be dealt with in one place or another. I think it's very different to have a family member sent to the state prison as opposed to Riverview. They say different things, they carry different stigma, and they just personally mean different things for that family. So if it's the case that the IMHU needs these 3 things in order to deal with this class of patients who are IST, why don't we create that environment at Riverview, which is actually meant for folks who are struggling with serious mental health? Do you see where I'm coming from?
I do. What I would say is a couple of things. Number one, some of these individuals, and I really want to underscore that predatory violence is not undertaken by somebody due to a mental illness diagnosis. Sometimes an individual may have a mental illness and engage in predatory violence, but some of the examples that Superintendent Bouffard will share are individuals refer to us when there was some question about there being a mental illness diagnosis. But when they came to us, it became very quickly apparent that there really was not a major mental illness diagnosis, that these individuals were engaging in their behaviors primarily due to sociopathic personality traits. And in that case, there's not treatment that's going to mitigate their risk. There's no medication or therapeutic treatment or group therapy that's going to have any impact. Another concern that we have is that when we're dealing with individuals that pose that type of risk, having them be in an environment such as Riverview, where we work very hard to cultivate a therapeutic milieu and work with individuals who have a mental illness diagnosis. Those people, because they're decompensated, their symptoms are very severe, are more likely to be potentially victimized. They're more vulnerable in that state. And so I very much share Representative Warren. You and I think have some similar background. I did what's called a community psychiatry. I was actually the chief resident of a community psychiatry residency program in Cambridge, Massachusetts. And I think we share a lot of the same philosophical approach and motivations for why we've chosen our respective career paths. What I would say is through my years of experience, there are the small handful of folks who really, I think, don't do well in our environment and potentially actually have other individuals that they can victimize, which leads to further problems for them, legal problems. And again, as I said, they're unlikely to respond to any treatment that we offer. From a regulatory standpoint, we simply cannot utilize some of the tools that the IMHU has, for example. I mean, we're talking about people who engage in serious lethal violence. Again, that is not being governed by a mental illness diagnosis. So the IMHU has tools that we simply do not have. And Superintendent Bouffard, I think, can speak to that in a little bit greater detail since he actually used to oversee the IMHU. But we couldn't even, for example, regardless of what is physically possible in terms of infrastructure, we could not, for example, confine somebody to their room behind a locked door for any period of time unless they had already done something. Even if we had the ability to foresee with a high degree of confidence that this was somebody that was planning something or likely to act in a dangerous way, we simply can't do that at Riverview. And I think that jeopardizes a number of folks.
Thank you. So I think that helped. So it isn't just folks that are incompetent to stand trial. It's also these sort of predatory. So there's this other class of people. It's not just ISD.
It's exactly, yes, and thank you for asking that, right?
That's what clarified it for me.
Yes, IST with that type of predatory violence. Yes, thank you.
Oh, wait, IST. So they are IST?
Correct. They're IST that we have assessed them to be at risk of engaging in this type of predatory violence and aggression.
So if they are IST, aren't we in fact talking about somebody with a mental health diagnosis?
Oftentimes, yes, but not necessarily, because
okay, I'll let others go. Sorry, I have to think about this. It's still a little confusing.
And I'm happy to speak at the work session as well. Yes.
Thank you very much.
I think we're going to be asking a lot more questions. Representative Pluker.
Thank you, Madam Chair. Yeah, I was going down that same lane as Representative Warren. So if somebody has no underlying mental health issue, but has sociopathic traits, I'm not a social worker or have any qualified, having to do with anything with mental health, would they be considered IST?
There's a possibility, yes.
Okay. And then we believe the IMHU might get them to a place where they would be competent to stand trial with those sociopathic traits, but without a mental illness.
Exactly. Yes.
Okay, thank you.
Yes.
And I'm going to ask my question, and if you can't answer it, Dr. Davis, I'm sure Mr. Bouffard's going to be listening and can answer that. I see such a mixture here because I'm going back to something maybe I think Dr. Bader mentioned. You could have someone who committed a crime and is being held at the Oxford County Jail, at the Machias County Jail, or what have you, a small jail that's, they can't manage him because he's violent, and they don't know if he has a mental illness. They might call the commissioner of corrections and out of courtesy saying, we need more security for this individual. Can you hold him for court? So he probably would be, I don't know how, again, maybe Mr. Bouffard will answer that. Then there are others who will be sent there by Riverview. Is that correct? I mean, you would have had them, you knew that wasn't really a mental illness that you could address other than he is violent and requires more structured environments such as IMHU. Is that correct?
Yes, right.
So,
yes.
Go ahead. Yes, I'm sorry.
No, we review, we have coordinators who review all of these referrals that are generated through the State Forensic Service, and myself and our admissions coordinator in conjunction with the State Forensic Service look at every single one for disposition, whether to Riverview or to Dorothea Dix, depending on a whole variety of factors. And this would allow us then to also consider the IMHU, with whom we have a very good working relationship, I should say. We consult with them on some of their challenging cases. I've given them some recommendations on medication management for some of their patients. So suffice to say, we have a really tight working relationship.
So I'm going to end with one more question. So if Riverview referred or was able to transfer an individual to IMHU at the main state prison, does he then become a Department of Corrections sole responsibility or yours?
He would remain ours, yes.
Okay, good.
Our commissioner, yes.
All right. Thank you. If I don't see any other hand raised, and I see Mr. Pluker, Representative Pluker, you still have another question?
Another question occurred to me. Do you, if they are at the IMHU and they do something violent or attempt to hurt themselves, would you see them potentially ending up in administrative segregation?
I'm not familiar with the term administrative segregation exactly as it's used at the DOC. I think Superintendent Bouffard could probably speak better to that.
Okay. Thank you.
Yep. Sure. Well, Your turn there, Mr. Buffard, and it is so great to see you again and again. We've been many decades together, so you can answer this, and I hope you also introduce yourself and your background. Thank you.
Senator DeChambeau, Representative Warren, members of the committee. My name is Rob Buffard. I'm the superintendent of Riverview Psychiatric Center. I started my career a long time ago, and I'm just going to hit the high points. I became the superintendent / bureau director at the time that Pineland was closing, and essentially managed the closure of Pineland Center. From there, there was a death at the Augusta Mental Health Institute. Healthcare Finance Administration was looking at revoking the license. JACO was looking at revoking the certification. I went over to AMHI. Within 2 years, restored their license fully. After a period of time over at AMHI, again, it had its full licensure when I left. In 2000, there were significant problems at the youth center, litigation, number of issues. And essentially, we flipped it from probably one of the worst facilities in the country to one of the best. I know there are some issues that have happened since I left, but I left in 2013 and essentially got transferred. I was given an option I couldn't refuse to go to the Maine State Prison. So I went to the Maine State Prison, worked at, again, assisting the prison with ACA, really looking at segregation, reducing the segregation hours. Went from the Maine State Prison to Associate Commissioner of Facilities for the Department of Corrections. I was looking over at Riverview and I thought, well, you know what? I'm winding my career down. They've lost their license. They've lost a lot of money. I approached Commissioner Mayhew, and essentially here I am at Riverview Psychiatric Center. I have received a number of awards formally by, the governor's office, NAMI 3 times, and a few other folks for some of the work I've done in my career. Getting back to Riverview, when I first came here, I was absolutely convinced that this was the appropriate venue for anybody that was admitted. And over a period of time, I became increasingly aware that there were some people that frankly we shouldn't admit, and that this really wasn't the appropriate venue, not only for those particular individuals, but the individuals that were really equipped to handle. And Matt's referred to the folks that are, predatory in nature. We're looking at a very, very small number of individuals. I think if you go back last year, it was probably 5 or less. The year before, it was 5 or less. And these people would rotate. If they were to come, they'd rotate in, they'd get reconstituted, and then, they'd go back to court. So it's a small number of people. And I'll just give you a couple of examples. When Dr. Davis mentions that, they're predatory in nature, essentially what happens is they put both the staff and the patients at extreme risk. I don't think I've ever worked at a facility where I've seen more staff get hurt with life-threatening with careers that ended. Okay, and I don't want to embellish that one way or another, but to me, if in a period of 3 or 4 years, you lose 3 or 4 staff with an injury that ends their career, to me, that's significant. That being said, there are a number of patients that we have to be concerned about, and the mere fact that these individuals are in the milieu is threatening to the patients. We basically have folks that are male and female in the same units. None of the doors are locked at night. And essentially the facility staffed well, probably one of the better staffed facilities that I've ever worked in. But the reality is somebody that's predatory in nature will wait for the right time to do something. And that's generally when they strike. I'm just going to go through two patients that we've had in the past, I would say, past 2 or 3 years. And I'm just going to read off some of the things that this one particular patient, and then I'm going to read a progress note from the psychiatrist. He was involved with 18 staff assaults and 1 patient assault. And the reason why he was involved in only 1 patient assault is because essentially what we did was we have special care units. There are 2 of them. There are 6 beds on a special care unit. What we did, because we didn't want any other patients getting assaulted, is we took the patients that were in that unit, moved them into the general population, or moved them into the larger units, the main units. We left him in that unit by himself. We had at least 2 staff and sometimes 3 staff with this individual. And even with that, now, Dr. Davis spoke about how it limits the flow of folks coming into the hospital. Well, right now, I've just taken 5 beds offline for this one individual for his length of stay. I've also increased the staffing to make sure that I have enough staff in that unit in the event that he attempts to assault them. And it's going to take more than 1 person to manage somebody like this. And I'll just go through, I'm just going to read a couple of things. I'm not going to go through the whole list because I don't want to bore you. But, patient head-butted staff member on the side of his face. Patient grabbed mental health worker's breast. Patient was upset. Basically, he was med seeking. He was upset that the nurse wouldn't give him the meds he wanted. He grabbed her in the breast. Patient punching and spitting at staff. I'm not going to read this whole list, but this individual basically, I use one more example. He asked the male staff if he could go outside. So we have a yard outside that we take him, it's fenced in. Staff went out and took him, had the radio, and as soon as they got outside, and this is what we mean by the predatory nature of these folks, he basically, the staff should have been paying closer attention. He flipped the radio out of the staff's hand and essentially proceeded to hit the staff. Obviously, we're fortunate enough to pick it up on camera and we had people respond. He assaulted, like I said, he attempted to assault a patient 3 times. And he did assault the patient once. After that, that was it. That's when we moved the other 5. I think we had 4 patients in there at the time, moved them out, put them in the main unit. This individual essentially spent a fair amount of time in the restraint chair. For those of you who know me, I don't believe in restraint. Essentially, the restraint beds on the lower units are gone. We still have a restraint chair. Our average on the use of mechanical restraints is lower, even though we have some of the most difficult patients in the state, is lower than a lot of the private hospitals. This gentleman spent a significant amount of time in the restraint chair. It was his preference. He basically would ask to go there. We put him in it. There were times, again, when you look at somebody that is somewhat a predator, he'd ask to go in the restraint chair. We put him in the restraint chair. And I know, because when we have difficult patients, I go down and I work with the patients along with the staff. So this is firsthand information. Put him in a restraint chair. He'd get in the restraint chair, be there for a couple of minutes. I need to go to the bathroom. I need to go to the bathroom. So at that point, you take him out of the restraint chair, then he assaults you. And I say that happened 2 or 3 times. Again, very thoughtful. He knew what he was doing, very planned. And what I'd like to do is just kind of read just from one of his provider's notes. We again reviewed why he has repeatedly engaged in these dangerous assaultive behaviors. He stated that it's due to boredom. We discussed alternative behaviors he could engage in to manage his boredom. Notably, he was lucid, logical, free of evidence of psychosis, thought disorganization, or mood disorder. I'm just going to jump to a different paragraph. He has stated, this is the provider again talking to him, he has stated that since his mother is his guardian, that means he cannot be held accountable for his actions. In my numerous meetings with him, I have never observed him to have any evidence of psychosis, delusions, paranoia, hallucinations, through thought disorganizations, mood disorder, etc. His behaviors over the past several weeks appear to be entirely volitional and in control, and it just goes on basically to say the same thing. So this gentleman pretty much knows what he's doing. He's planful, and I can tell you that on more than one occasion during the off hours, I came to help I drove up to Riverview to help deal with this particular individual, which is what happens when we have individuals like this in the hospital. I could go through another one if you folks wanted me to, but the bottom line is, and I really want to emphasize this, we're looking at a very small number of patients. And if we had this small number of patients at the IMHU, we would be able to actually take more people from the jails who really need our services, as opposed to having some of the backlog that we currently have. The system would move a lot quicker. I'll just read the last part of some of the points I wanted to make, and then I certainly would be willing to answer questions. As previously indicated, I'm currently the superintendent of RPC and was the warden at the Maine State Prison when the IMHU was developed. I understand the program pretty well. I was there when the program came together. As such, I have the unique understanding of how both programs operate and the services they provide. And I can tell you, I have two people in here right now from the IMHU, and a couple of the things that they've said to the staff. The time that they had over there, they found very beneficial, and they found that it was very helpful for them. And as Dr. Davis said, we work with the IMHU quite closely. There are some things that, believe it or not, we've learned from them, and there are some things that they've learned from us. One thing that we've learned from them is all the patients, not all, most of the patients on that IMHU unit have iPads. The iPads actually have cognitive skills programs in the iPads that the patient can do on their own time. They can answer the test, and after they're done with that, they can actually watch TV on that iPad, and they can play games on that iPad. Something that clearly we're looking at getting here at Riverview when COVID goes.
Superintendent Bouffard? Superintendent Bouffard?
Yes.
Thank you. I want you to know that we'll definitely read your testimony, so you don't need to read it to us. And it might be helpful for committee members to be able to ask you questions, because I know you have a lot of great information. Do you mind if we move from testimony to questions?
It's fine with me.
That would be great. I know everybody's going to have a lot of questions for you, so thank you.
I guess it's okay. Anyone have questions for Mr. Bouffard? Representative Warren.
Thank you, Madam Chair. So I have the same question for you, Superintendent Bouffard. If we know that we have these folks and we need that more restrictive environment, like you said, you had to turn your, did you refer to it as a special care unit?
Yes.
That you had to turn your special care unit into sort of a lockdown, or I don't know what you would call it, but why don't we create that at Riverview?
Just going to come back to what Dr. Davis said. The CMS regulations require us to follow their guidelines, and there are certain guidelines. For example, at the IMHU, and I think Dr. Davis already alluded to this. If a patient, when they go to bed at night, the doors close and they lock. Nobody has to worry about whether or not they're going in their room. Nobody has to worry about them getting assaulted in the middle of the night. Their ability to use seclusion is, and I'll call it seclusion for the sake of this conversation, but their ability to use seclusion is far greater than our ability to use seclusion. They're equipped to deal with some of the more dangerous people that the state has.
Thank you.
I raised my hand so I wouldn't lose my place. I'm going to ask you, and thank you for stating about you follow, you're required to follow the guidelines of CMS or the rules of CMS. I was surprised to hear about the restraint chair. I know the prisons have restraint chair. Is a restraint chair used, do you know, at the prison at IMHU?
I think it's available, but I feel, when I was there, it wasn't used in any real significant kind of way, if my memory serves me correctly.
Okay.
Essentially, what people opt out, what people opt to do is use a least restrictive approach. And generally speaking, before putting somebody in a restraint chair, they'll use seclusion. They'll call it something different over there, but it's seclusion.
Yep.
And I know there was somebody that asked a question earlier about whether or not one of the IMHU patients would go to segregation. They would, if there was a need to segregate somebody in the IMHU, they would segregate them in that unit. That unit basically, I'll speak to when I was there, and I believe it's the same thing. That unit is really it's enclosed. And the patients who go there get treated there, and they're not going to go to a segregation unit that's the prison segregation unit. They'll put them in a room on that unit.
Thank you. So instead of a segregation unit, we call it obviously restrictive housing. It's restrictive, it's moving to another one. Do you know for a fact in the use of a restraint chair, if your department and the Department of Corrections have the same policy of what you can and can't do and how long you can keep someone in a restraint chair?
Well, again, I'll speak to my memory. When I was at the prison, we only used the restraint chair to the extent that we needed it. When the person no longer posed a threat, they were removed from the restraint chair. I don't think you're going to find they use the restraint chair in a significant way at the prison. I think you'll find that they use probably what they call seclusion or segregation. And again, we don't use the restraint chair much here at all either.
Okay, I don't want to belabor the point, but all right, I was just curious. Thank you. And Representative Luckner?
Thank you, Madam Chair, and thank you, Superintendent Fard, and for your work over the years on, with these folks. My question, so who makes the determination about whether or not somebody is competent to stand trial? Is that something that there's a real specific clinical set of criteria that must be met?
Yes, and if you don't mind, Dr. Beta would be more knowledgeable relative to that issue than I, and if I could defer the question to her.
Yeah.
If that's okay, I'm happy to. I worked for 13 years at the State Forensic Service, whose primary function is to do court-ordered evaluations on criminal defendants. The most common court-ordered evaluation on criminal defendants is competence to stand trial. So we'll get a court order for competence. The State Forensic Service will evaluate the defendant, write a report, submit that report to the court. The court will have a competence hearing. We'll hear testimony relative to there are several factors that we examine with respect to competence: ability to have a factual understanding of the legal system, their ability to sort of appreciate their own legal situation, and their ability to assist their attorney in their own defense. Those are sort of the three, what they call dusky prongs for competence. and the judge will weigh evidence with relative to those prongs and then render a finding. And a finding of incompetence to stand trial suspends the rest of the legal case until the competence issue is resolved. And once someone is found IST, there are several things that can happen. If they're low risk to public safety, well connected to services in the community, amenable to treatment, we divert them to community-based competence restoration. If they're acutely ill, require inpatient level of care and competence restoration, off to Riverview or Dorothea Dix they go. This bill would allow that extra choice for that small number of defendants who are very, very dangerous. But it is a court finding that the judge revisits at the 60-day mark, the 90-day mark, and the 180-day mark. So it's about a 6-month process that the court allows to see, is this person going to get competent so we can proceed with the rest of their case? And if they do, and are found subsequently competent by the court, they go back, typically back to jail to await the disposition of their case. And sometimes if they're found non-restorable, if they're found non-restorable, their charges are then dismissed by law and they're released from any correctional facility that they may be in.
Great. Thank you for that, Dr. Bader. And I guess, may I have a follow-up for either Dr. Bader or Superintendent Bouffard?
Go right ahead.
Thank you. So where are these folks held then prior to that determination? Are they in county typically? Or they, I assume they're in some kind of, they're already in the states. Are they in county jail or where are they?
The vast majority of them are in county jail. And so especially the population we're talking about are definitely in county jail. On very rare occasion, they're out on bail, but they're obviously, if they're out on bail, they're considered by the court to be at relatively low risk.
Right. And county is ill-equipped to provide for the needs of these folks as well.
They're not allowed they don't do competence restoration. So they sit and wait in county jail prior to being placed either in the community, if they're, as I said, low risk and amenable and connected to treatment, or they wait in jail to come to Riverview or Dorothea Dix, because those are the facilities that are that provide competence restoration and treatment.
I see. Thank you.
All right. I have Representative Pickett.
Thank you, Madam Chair. I guess this question is for any one of the three that wants to answer it for me. So as I'm hearing the testimony here from the three of you folks, and it's been very enlightening, it sounds to me like the being found incompetent to stand trial is really not the issue here as much as the fact that the ones that end up and should end up in the other unit are the ones that have this predatory and institutional aggression, correct? Would I be correct in assuming that?
Yes, we're talking about people who are currently adjudicated as incompetent to stand trial, the subset of whom engage in this seriously lethal, dangerous, predatory violence, correct?
Okay, so.
And I'll just add, if you don't mind, I'm just sorry, the folks who are not incompetent to stand trial and are highly dangerous have other mechanisms to get to the intensive mental health unit. Right now, there is no provision in the law to allow an incompetent to stand trial defendant go to the IMHU, someone who's highly dangerous. So that's the purpose of this bill.
And that's what I was trying to get at, because as I read that, it says, and not directly in response to mental illness, to a mental illness diagnosis. So that's what I was trying to get at, that the one we were just talking about, the predatory one. So it actually, those are the ones that you're concerned about, and those are the ones that few and far between, but when they do come in, they're very difficult for you to handle there. And the staff over to the other facility are trained to do that kind of stuff. And also it's a safer environment for you, but also for them when they're in that environment. Is that correct?
Yes. I would absolutely say that's correct. And essentially, I would actually argue that for the folks that we're talking about, their ability to recover in that environment would be quicker than their ability to recover in this environment because of the structure that's being imposed.
Thank you very much.
Any other questions from anyone else? I would like to ask Ms. Overton for the work session. I would like to get from the Department of Corrections a list of the training, specialized training the officers have, if any, for IMHU. And I think that's enough for now. Well, we this was the presentation basically, and we asked questions. I'd like to turn it over to anyone who wishes to speak in support of this bill. Are there any, Ms. Fay?
So the process would be that if you are here, please raise your hand if you'd like to speak in favor of the bill, and Ms. Fay will bring you over to testify. We'll then do the same for opposed and the same for neither for nor against.
I am seeing no hands in favor.
Go ahead, Senator.
Anyone wishing to speak?
One just went up.
Okay.
One moment.
We're in support. Ms. Black, are you here to speak in support?
I think I bought her over an accident. A hand went up and then went down. Sorry.
Wasn't mine. Sorry, not me.
It wasn't yours. Okay.
Marianne Lynch, her hand's going up and down. I'm going to bring her in because I'm not sure.
I am asking, and we are at the point that anyone who wishes to speak in support of this bill. Ms. Lynch, you wish to speak in support?
Yes, thank you. And I apologize. This is the first time I've attended this. I'm usually out in the hallway. I miss seeing everybody. So I apologize for my my difficulties with the technology. I am here representing the Maine Prosecutors Association. We are testifying in favor of this bill with a caveat that the district attorneys wanted to be clear that anybody there should not be housed with the general population. Senator Warren, you said something that really rang true to me. I also grew up in a very similar background. When I say grew up, I came up as a social worker through the system, and I certainly have been through deinstitutionalization. The struggle we have, and I'm constantly talking to Dr. Bader about this, is the issue of inventory. I don't want to take up everybody's time. I think the information that came out of the CLAC meeting is important, that very often these people who have been found not guilty are really languishing at our county jails, waiting for these placements without any treatment. It's not a perfect situation, but we are just in need. All the counties, all the district attorneys are articulating that for additional availability, additional beds, And particularly, as we've discussed, these very hard to place individuals that place a tremendous amount of pressure on the limited resources, particularly in the county jails. Thank you very much. Thank you for being patient with me and my technology struggles.
No, that's quite all right, Ms. Lynch. So the association, basically the caveat that they should not be, these individuals should not be placed in general population of the prison, correct?
That is correct.
Thank you. Thank you very much. I have asked a few times if anybody wishes to speak in support. I will then move on to if anyone wishes to speak in opposition to this bill. Raise your hand, please, and we'll let you in.
Hands are going up. I'll bring in 3 people.
Thank you. And there are more, Ms. Fay?
Just 3, it looks like.
Okay, thank you. I recognize Tina Nato. Sorry, I should say Miss Nato, but go right ahead. Followed by Simone Meline, I believe, and Michael Cabetta.
Good afternoon, everyone. My name is Tina Nato, and today I am speaking on behalf of the Maine Association of Criminal Defense Lawyers in opposition to this bill. Shakespeare has written, a rose is a rose is a rose. Well, a prison is a prison is a prison. I understand my clients, my colleagues' clients sometimes are very ill and can be violent. This bill will imprison them. I am so confused as to why DHHS is not standing before appropriations and begging for the funding needed to set up a facility that meets the needs of these particular individuals. Somehow we found $8 million to reopen a prison down east. Somehow that money is just available to DOC whenever they need it. This is essentially refunding DOC in another way. IMHU was not set up to restore incompetent people. It was set up to help people in crisis who are sentenced for crimes to Maine State Prison. IMHU should not be used for anybody who has not been convicted of a crime. Just turning to my testimony, because that's my reaction to a lot of what's been said here.
Thank you, Ms. Nato.
No, I'm turning to my testimony, my written testimony.
Oh, go right ahead.
Sorry. We should not be authorizing the state of Maine to hold our people in a prison, no matter how therapeutic that part of the prison is made to be. This is a slippery slope that provides and justifies even more funding to DOC while not addressing the chronic underfunding and under-resourcing issues facing DHHS. We don't want our clients to suffer. We don't want them to hurt people, but we also don't want them to be housed in a prison because they're so severely ill that the court has decided they can't even defend themselves against the charges they're faced with. There must be a better way to address the issues concerning people who are deemed both mentally ill to the point of incompetence and dangerousness. Putting them in Maine State Prison is a huge step backwards, and I would ask this committee to potentially look at the loopholes that allow people who are not convicted of a crime to be housed there now. Because there's some people who aren't even mentally ill who are just too much of a bother at local jails that get shipped off to IMHU, and that's also a problem. So I respect the opinions of the DHHS people who testified here today, but it's not the appropriate place for our clients. And we ask that you reject this bill. Thank you.
I will now call upon Simone Meline or Maline. I'm sorry if I missed.
I'm sorry, are there any questions?
Oh, excuse me. You're right. Thank you. Thank you.
Of course, Senator. Thank you.
It really has been a long week. Never mind.
It really has. I agree.
You are number 20 or so. All right. Any questions of Ms. Nato? Thank you. Representative Pickett.
Yes, thank you, Madam Chair. Thank you, Ms. Nettle, for being here and testifying. Just have one question, response to your testimony. I understand your concern for putting a client into a facility that's incompetent to stand trial. I understand that. But would you want to put them into a facility where they now are and where they are hurting other people who are trying to give them the help they need, when you can put them in a facility where they can get the help they need and also be dealt with in a way professionally that people know how to handle them? I guess that's the thing that I'm having a hard time getting my head wrapped around. Because I understand what you're saying, but I think that we're talking about a unique set of people, it sounds like, that need a unique set of treatment. And so we want to give them the best treatment we possibly can, and we want to be in a setting that is going to be able to do that. And if we do not have one presently outside of the prison, then until we get one, isn't it best for them to be where they would not hurt other people and where they can get help?
So I'm going to parse the question a little bit. It's not about what's best. It's about what is appropriate. And again, housing people in a prison is not appropriate. The prison is not set up for restoration services. That's the stated purpose of this bill, which I don't believe is written very clearly at all. I think it's a bit confusing as to which incompetent defendants are actually going to be there. But regardless, there is restoration services that are in the gambit and control of DHHS. That's not being done at that facility. So again, DHHS has made the choice that rather than advocate for the resources they need to do their statutory duty, which is to restore clients in their custody, they find it easier to kick them down over to Warren. So there's no great here. There's no, oh my God, I'm satisfied with my clients suffering or being able to hurt people. Of course not. But let's do something better. We have the money to incarcerate at an $8 million initial price tag such low-level offenders, apparently in Down East Corrections, the renovated Down East Corrections, that they can actually work in the community all day long. But we're willing to throw money at that, but not provide the resources needed. I think a doctor yesterday testified in a similar bill. We need 10 facilities throughout the state to actually deal with people with severe mental illness who may be facing criminal charges or who may just be so ill that they can't live in the community. But we don't have that. And why don't we have that? Because of bills like this that open the road and widen the road back to prison. We always are able to fund DOC, MSP, DPS. Let's fund DHHS so that they can do their statutorily sworn duty to restore people to competence if they possibly can.
Thank you.
Thank you.
Any other questions for Ms. O? Representative Morales, you have a question?
Thank you, Madam Chair. Thank you, Ms. Neto. I was wondering, my mind is going to housing and housing first programming, and whether you've had clients and can speak to how providing housing with supports for some folks, particularly those with severe and persistent mental illness, if that's helpful and if you've seen that in the past.
Just 1 second. The maintenance guys are mowing. Sorry. Oh, they're actually lawn blowing.
We can't hear them.
You can't hear. Okay, well, I can hear them. So can you repeat the last part of your question?
Yes, well, I could try. I'll just ask it again. Thinking about some of your clients, whether they have housing needs, whether they have treatment needs, and when you put those together in housing first models for those with severe and persistent mental illness, have you seen, first of all, do your clients have those kinds of needs? And then is a housing first model, things like that, helpful in a way that we can think about this differently?
Yeah, I think housing is always a concern for all of my clients, or nearly all of my clients, particularly those who suffer from severe mental illness, so schizophrenia in particular. I know there are progressive treatment programs that kind of incorporate the housing element as well as like treatment with that. So for the types of defendants that this bill is concerned with, I don't know if housing is necessarily the thing. It's hospitalization. It's therapeutic settings that are not carceral settings. So I agree. Anytime we can expand housing for people who are mentally ill and get them in the lowest level of care needed, so if it's in the community or not, great. But for these particular people, because they're in crisis or they're unmedicated or there's something else going on, I don't disagree that there are some dangerous folks who are suffering. There was a lot of testimony about the dangerousness. We don't disagree with that. We just disagree with placing them in a carceral setting so that I guess it's easier to cage them. I mean, that was something that Dr. Davis said, if not directly, then by implication. DHHS is too hard to restrain people or confine them, but it's so much easier if we send them to the prison. That's a problem. So thank you for your question.
Thank you.
Any other questions for Ms. Nato? Seeing none, I will now ask Simone to speak for us. Thank you. Ask the question.
Thank you. Good afternoon, Senator DeChambeau and Representative Warren and esteemed members of the Criminal Justice and Public Safety Committee. It's my first time in front of you this session. My name is Simone Mallon. I'm the Executive Director of the Consumer Counsel System of Maine. And we are an organization that is in statute, state statute, to help state government and the legislature and anyone else that wants our help to look at public policy and give good decision making and advice from the perspective of people with lived experience who, I have one of those serious and persistent mental illness diagnoses as well, and as do folks that participate in our organization. And we're here today to oppose this bill. I'll try to be brief because a lot of things have been said today, but I want to point a couple things. This is not the first time we've heard this similar bill. In fact, in 2016, LD 1577 was blocked from passage from the Maine Senate. And unfortunately, we're here to do this again. And I want to say I have incredible respect for Superintendent Bouffard and the staff at Riverview. I work with them as well, and I think they do amazing work. But we are talking about people who have been deemed by the court as the incompetent to stand trial label, and we're talking about putting them in prison. Because we are already, we're looking at expanding that door, and that's incredibly frightening. In the early 1900s, we didn't have a Riverview for forensic folks. But in their wisdom, they created a wing at what was then the Maine Insane Hospital, and brought people from Thomaston, which was where the prison was at the time, to the state hospital for treatment. And this feels like we're again fighting in many ways to move backwards in time to a way that has proven not to work. What do I see as solutions? Because I don't ever come without trying to think of solutions. And Ms. Neto said one that I am going to say. It's probably expensive, but we need to fix Riverview. And if you don't know, originally when Riverview was designed, there are architectural designs to facilitate expanding it. The unit is set up in a way that makes it very easy for assaults to happen. And if we create a unit that can work for everyone, we would not have to send people to the IMHU. And so, and the other thing about the IMHU is there is no CMS oversight. You're not helping people make sure that their their care and their rights are taken care of. Well, CMS won't look at rights, but so I see my blinking, I'll stop, but those are important things that need to be considered. Thank you.
Thank you, Ms. Maline. Any questions for Ms. Maline? Seeing none, we will proceed with Michael Kibeta.
Thank you, Senator DeChambeau, pronounced like a native Ethiopian, and represent and distinguished members of the committee. Good afternoon. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine. On behalf of our members, I'm here to testify in opposition to this bill because it would threaten the constitutional rights of people in Maine and would undermine the fundamental principles of our criminal justice system. The framers of our Constitution were profoundly aware that unchecked governmental authority was a threat to individual liberty. Our republic was founded on the bedrock principle that the government should not be able to reach out and strip the liberty of those who are merely accused of wrongdoing. The framers wrote the Bill of Rights to protect each individual from the full force of the state. Accordingly, the rights of criminal defendants are protected by more constitutional amendments than almost any other right. The Fourth Amendment protects the individual from unwarranted search and seizure. The Fifth Amendment guarantees due process and guards against double jeopardy. The Sixth Amendment provides for legal counsel. The Eighth Amendment prohibits excessive, cruel, and unusual punishment. And the 14th Amendment provides substantive and procedural due process and ensures that everyone is equal in the eyes of the law. In this country, we have a criminal legal system to determine who goes to prison. It has its own set of constitutional protections and its own process: arrest, arraignment, discovery, a trial before a jury of peers, a conviction based on the beyond a reasonable doubt standard, and sentencing by a judge. That's the way that someone should ever go to prison. If someone is determined to be incompetent to stand trial, that person has not been convicted of a crime. That person is not a prisoner. In other words, someone who's determined to be IST is legally innocent. They may find themselves civilly committed if a judge determines that they pose a serious risk of harm to themselves or others, but they are not a prisoner, and they may not be sent to prisons. You've heard that prisons are not hospitals. We agree. Prison cells are not therapeutic spaces. Prisoners have a right to only adequate health care under the law, a low standard that only requires that prisons are not deliberately indifferent to a person's health. We are enormously skeptical that a prison could provide better health care than a state hospital. We've heard that it might. If that is the case, we encourage this legislature to focus on improving health care at Maine's hospitals and Riverview instead of transferring patients to prison. DHHS is charged with improving the health and well-being of Maine residents, treating consumers with respect and dignity, and delivering evidence-based services. Putting patients in prison flies in the face of these goals. This is not the first time, as you've just heard, that this idea has been before the legislature. Past legislatures wisely rejected similar proposals because they correctly understood it to be inconsistent with our fundamental constitutional values. We urge the committee to affirm its commitment to those values and reject this bill. Thank you, and I will try to answer questions.
Thank you, Mr. Cabetta. Anyone have any questions for Mr. Cabetta? Seeing none, I will ask if there's anybody else in the waiting room that wishes to speak in opposition of this bill.
No hands in opposition.
Okay, before I go to the next, did I lose Mr. Cabetta? I had written a question and I had forgotten. Hello.
No,
and thank you for bringing up constitutional rights and what have you. There was a statement made in one of the presentations that our neighboring state, New Hampshire, has a similar relationship with their mental hospital as is proposed in this bill. Are you aware of that?
Yes, and I'm also aware that constitutional rights are routinely violated and nothing happens. Unfortunately, the fact that we have rights doesn't mean those rights are always respected. What I'm doing today is asking this committee to respect the rights of everyone in Maine that the Constitution gives them.
Thank you.
Absolutely.
Representative Warren.
Thank you, Madam Chair. I almost didn't unmute myself. Just a very quick question. I'm going to be asking for the definition of incompetent to stand trial. And I'm sure Ms. Orbanen is going to get that for us. Michael, could you also, for our work session, sort of bring whatever you have sort of for background about, you know, why do we have this standard, right, of IST? Ms. Neto described it as the court has decided this person cannot defend themselves against the charges against them. I think it's important for us to think about the foundation of that. So if you could bring me any, or bring the committee, excuse me, any material, that would be really helpful. And I just want to say, I think you said it really well, which is if we find ourselves as a state in a position where the hospital care we can give Mainers is better inside the prison, and so we're looking at sending folks there, we should probably look at our hospital care. I think that you really summed it up quite well. So thank you for that. And thank you for getting me that information.
My pleasure. Thank you, Representative Warren, and I'll get that information to the committee by work session.
Thank you. Anyone wishing to speak neither for nor against this bill, please raise your hand. We'll bring you over. I guess seeing none.
There is one.
Kevin Levodich.
Yes, thank you.
Thank you.
Thank you. So good afternoon, Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Kevin Voivodich. I'm an attorney at Disability Rights Maine, and I'm here today to testify neither for nor against this bill. Now, I testify neither for nor against, but with extreme caution being needed when looking at this bill. I testified against 1577 previously. I think there are concerns on both sides for both safety of other patients and these IST individuals. But I also think there's some very important legal considerations that this bill, as read, does not lay out. So first, I'd like to make 3 points. So the IST, Representative Warren was asking about IST. When you are found IST, there's a DUSKY standard that's used and described related to your ability to work with your attorney, understand the charges against you. I don't have it exactly in front of me, but it's a pronged standard laid out by the Supreme Court as far as what that definition is. And the Supreme Court, furthermore, in Jackson v. Indiana, the Supreme Court of the US pointed out that once you become IST, you have a different consideration about why you're being incarcerated. Even anybody that is waiting to stand trial, is held. That incarceration must be rationally related to a legitimate, non-punitive government interest. And that's Bell v. Wolfish. And for those incompetent to stand trial, I think in the first bullet of my testimony, I think it's very important to understand that when you are holding that person incompetent to stand trial, the continued commitment must be justified by the progress towards the goal of restoring the person to competency to stand trial. And there's nothing in this bill that guarantees that. Riverview and others have done that for years, but there's really no guarantee, and DOC hasn't in the past done that. So I think that should be some pause for concern, especially because it's not specifically laid out. And I will point out in 1577, when I was listening to the testimony, one of the doctors from the prison specifically testified, if I remember, that it is not hospital level of care at the prison. I want to be clear about that. That's a different environment. And the folks that they were talking about today are going to be sent there for security purposes. 2, this bill has a more probable than not standard. I think that's the wrong standard. It should be clear and convincing evidence. More probable than not is, preponderance of the evidence greater than 50%. If you're going to incarcerate someone, if this bill goes forward, it should be clear and convincing evidence, such right below, reasonable doubt, just like is used in commitment hearings today in Maine for civil committees. 3rd, if this bill passes as is, I would suggest that it have a sunset provision, because even if the folks in the administration are well-intentioned now, the way it's written has a strong likelihood that it could be misused in the future by future administrations. And I just want to point out, as I was looking at the bill today and listening to some of the testimony of Dr. Davis, the bill specifically talks about due to mental illness, the person poses a likelihood of serious harm. So I just want to end with that, because that's not what I was hearing earlier in the earlier testimony. And I think that right there leaves a lot of pause for concern for me, because that is the psychotic person or the person with another bipolar disorder or something that is described in Part 1A of this bill. I'd be happy to take any questions. Thank you for your time.
Thank you. Mr. Vovodich, right, Attorney Vovodich. Any questions of Attorney Vovodich? Representative Morales?
Yes, I was wondering if Attorney Vovodich would be available for the work session.
Yes, I would. Thank you.
Thank you.
Seeing none. It's not a statement, but that's a good suggestion from Representative Morales, because if you hadn't spoken, Attorney Vovodich, what you pointed out in the bill is exactly what disturbed me. It does not clearly stated. I've heard the terms psychotic. I've heard a number of terms, predatory. It's not, I guess, an official or what have you, but the likelihood of harm. There's a lot of things that I think this bill needs a little cleaning. The first one, A, does not have, it just says one specific. B has an "and" in it. The question was asked by, I believe, Representative Pluker, asked if number 2, the commissioner may terminate, if that was DHS. I'd like that to be clear, because if you go to 1, it says the commissioner may accept the placement. That sounds like a DOC. So you can read this whole thing and it doesn't specify which commissioner. We'll talk about that in the workshop, I'm sure. So anyone else have any questions at all? None, for neither for nor against. Thank you. Therefore, I will close this meeting on LD 769. And Ms. Overton, are we scheduled for a workshop next week, is it maybe? Or what? A workshop, work session, a workshop.
Yes, work session is next Friday at 1 o'clock.
Thank you. So again, I will close this meeting. There, boom, it's closed. Thank you all for asking questions and making presentations. It's quite enlightening. Thank you. The next bill we have is 769. I apologize.
It's me, LD 782.
Yes, I'm sorry. I completely lost track in where we were in the line. Yes, LD 782, an act to implement the recommendations of the Department of Corrections for certified batterer intervention programming. And Chair or co-chair Warren, it is your bill. You may give us testimony. Thank you.
Thank you, Madam Chair. Senator DeChambeau and esteemed members of the Joint Standing Committee on the best committee at the legislature, Criminal Justice and Public Safety. I'm here today to present LD 782, an act to implement the recommendations of the Department of Corrections for certified batterer intervention programming. Maine's certified batterer intervention programs, or CBIPs, are a primary mode of intervention in Maine's criminal justice cases that involve domestic abuse and violence. The 128th legislature, in providing initial funding for partial reimbursement of program fees for indigent participants in CBIPs, directed the Maine Department of Corrections to study the effectiveness of these programs and report back to this committee, our committee. Over the last 2 years, the Maine Department of Corrections has collaborated with the Maine Coalition of Domestic Violence and their member programs to conduct this study and report out the results. We received this report earlier this session in January 2021. And we heard from the folks, you'll remember, at the coalition, and also folks from the Department of Corrections. We learned that in fact, completion of these programs is correlated with a decreased risk of rearrest compared to those who are referred and do not complete, and that victims tend to feel safer when the participating defendant is enrolled in or has completed the program. As we've discussed at length here in our committee, it's essential that the state continue to support those criminal justice interventions that are shown to be effective at enhancing community safety and that also respect the capacity of people who have committed a crime to learn from it and to change. CBIPs accomplish both of these goals and warrant our continued support. That is what LD 782 represents. The report we received back in January includes recommendations on how we can make these programs better and attend to the safety of victims of these crimes, as well as to the accountability of participants ordered to complete these programs. I'm bringing forward a proposed amendment to the concept draft that primarily does two things. And I want to say, before I go any further, this proposal that I'm bringing forward today was 100% worked on by the coalition and the Department of Corrections. They have been working on this, and that's why we are bringing forward to you today the language of their proposal. I am merely the carrier of it. The first thing this amendment does is change how we refer to these programs from certified batterer intervention programs to certified domestic violence intervention programs. This moves Maine towards a growing best practice of labeling behaviors instead of people. Also, by shifting away from batterer to domestic violence, it better captures the full range of behaviors that these programs are designed to address. The second thing this bill does is to improve information sharing across the board. It does this by requiring the state, in ordering a defendant to participate in an intervention program, forward a copy of the relevant incident report as well as the victim contact information to that program. This allows the program to better engage with the participant about the underlying reasons that a person has been ordered to better engage, has been ordered to the program, and it increases the likelihood that the victim is receiving timely and effective notice and connections to critical community supports. The amendment also requires a victim to be notified when a defendant's probation is terminated early as a result of CBIP completion. So again, I originally had submitted to you all a concept draft. What I'm submitting to you today is an amendment to that, which represents a full bill proposal. I thank you very much for your time and consideration, and I'm happy to answer any questions that you have, although the experts are definitely coming behind me. Thank you.
Any questions for Representative Warren? Representative Warren, you listed, I think, 3, maybe 4. Number 2, I want to make sure improve information sharing by forwarding, and I didn't know where that was going.
So my understanding is this is information sharing from the state of Maine DOC to the Coalition to End Domestic Violence. But if I'm wrong about that, this is really about their partnership. They can correct me. So
Okay.
that question would probably be better
Yep.
for them who are here. Thank you.
Thank you. Seeing no questions, I will ask anyone wishing to speak in favor of this, in support of this bill. Please raise your hand, those of you who wish to speak in support, and we will bring you over.
I see 2 hands so far, 3 hands.
Whoever had the fiddlehead, I like that. Okay. All right. Well, I first saw Karen Ryman. I then will go to Fay Lupi and Anna Black. Those in favor. So Ms. Wyman, you may proceed.
Thank you so much. And thank you, Representative Warren, for that introduction to the bill. It's been really exciting to work on this. I'm Karen Wyman. I'm the Violence Prevention and Intervention Coordinator at the Maine Coalition to End Domestic Violence. And I'm excited to share my support for LD 782 today. Over the last 2 years, my role has been to coordinate and provide technical assistance to Maine CBIP providers to work with the Department of Corrections to create and implement appropriate policies and protocols, to foster connections with national and international experts in this kind of programming to ensure quality programming across the state, and to coordinate and support the response of the domestic violence resource centers in their outreach and services to survivors who have experienced abuse by participants in these programs. So I bring a perspective that's both broad in scope and well-versed in the minutia of how both sides of these services operate. And I ask you to consider that these changes support both the safety of victims and meaningful accountability for offenders. And I'll start with the change in language from certified batterer intervention programs to certified domestic violence intervention programs. And this is important because battering and batterer are specific labels which connote a narrower range of actions and offenders than the more accurate domestic violence, which conveys the full range of tactics used by people who abuse. And it updates Maine's statutory language to align with national trends that focus on labeling these behaviors instead of people, as Charlotte said. I'm sorry, Representative Warren. I'm one of her constituents. And this
And my
change,
neighbor.
this change echoes what we hear from survivors, that they want the abuse to stop. They're focused on the behaviors, and our language should reflect that. The bill also improves information sharing to enhance victim safety and dependent accountability. And it requires the state to share information it already has, incident reports from law enforcement and last known victim contact information, with certified programs when a referral is made to those programs. And this gives programs complete and accurate information about why somebody was ordered to class and allows for timely notification to the victim of their status in the class. We should not rely on the people who committed domestic violence to provide this information, but that is the current practice. We cannot assume that that contact is safe contact, and we should not continue to put court-ordered participants in a position where they think or can argue that they were encouraged to contact victims to comply with their program expectations. There could be probation conditions, protection orders, or other means in place to prohibit that contact. It is safer, more efficient, and more reliable to share information between organizational entities, and survivors have identified the need for timely and effective information as a key component for their ongoing safety. I see my time blinking, so I will thank you for your attention to this important bill, and I hope to see your unanimous support for LD 782, and I'm happy to answer any questions you have.
Thank you, Ms. Wyman. Representative Reckitt. Yeah.
As Karen, I assume you know, but you may not. I was involved in the operation of CBIP programs from 1979 till 2015, and have not always been the biggest fan of them. But my question today is, when you say the information sharing from the police reports, which would include the last known victim contact information, what I want to know is there a possibility or a mechanism for the victim to opt out of that information being shared? I'm certainly aware there are some victims whose danger is so high that they do not want that information shared with anybody. is there a, whether you or maybe Ms. Lupi would know that information, but I'm concerned that there needs to be some way for victims to indicate they do not want their last known address shared with the perpetrator of the crime.
Thank you. That's an important question, and we really we want to consider any potential unintended consequences on victim safety throughout our thinking and planning around this. There are protections in the CBIP standards that allow for an exception to customary practice if there's a concern about victim safety. This information would be coming from the state attorney's office to the intervention programs. It's information that the CBIPs request from participants currently. So I'd be really curious to think in the work session about if there are additional protective measures we should take, but the information is not being shared with the perpetrator, the person who's referred to the intervention program, but with the program staff itself. So I don't know if that helps, but I think we should definitely look into ensuring that there aren't negative unintended consequences for victims. Thank you.
Thank you.
Thank you. Any other questions? Representative Pickett?
Yes, thank you, Madam Chair. And thank you, Ms. Wyman, for being here. The question I have is, having been involved in law enforcement for 40 years, a number of those years working cases with child abuse, sexual assault, those kind of things like that. My question is this. I know that back years ago when they first started putting some of these programs together for defendants, which I think is a real good thing, and a person that was convicted of child sexual abuse or that kind of thing like that had a program to go through, and they would go through that program as part of their sentence. My question to you is this: have you noticed or having any kind of issue with some of the people who are getting involved in these batters, these, what's the new language, domestic violence programs? Because the question I have is, are they doing it? Are you getting any that are doing it just because they're ordered to do it? Because I think you would agree with me, maybe not, but if a batterer or a pedophile or anyone of that nature, if they don't recognize they have a problem, you can put them into a program and they may do it and do that program knowing that there may be a reward for it on the other end, maybe a lesser sentence or whatever the case may be, but yet they really do not recognize the problem. And so have you noticed any of that, or does it seem to be really working well?
Thank you for that question, Representative Pickett. And I think it's a somewhat nuanced answer. You're absolutely right about the importance of personal motivation and that sense that real accountability comes from within. And it is not enough for every offender to be ordered to a program to kind of light up that desire for change. With that said, for some offenders, it is a wake-up call and that they take seriously and really use as an opportunity to re-examine their beliefs and the actions that they've taken based on those beliefs. And regardless of motivation, during the time that they're in that program, they have increased involvement in their lives through the educators and through whatever referral source has brought them to that, whether it's probation or judicial monitoring or child protective services. So there are additional eyes on that person and monitoring their behavior. So we see gains in safety that way. So it is not a cure-all, it's not perfect, but it's certainly, we are seeing overall increases in safety for survivors. And what we understand from survivors is that even if things aren't 100% better, if they get better by degree or for a period of time, that is a valuable change.
Thank you very much, and thank you for your work in this area. It's a very important issue, and really appreciate it.
Thank you.
Ms. Wyman, I have a question, and I don't know if it's for you but I will say it because I don't want to forget it. And maybe I think the Department of Corrections will respond to it. I'm still having a concern somewhat the same as Representative Reckitt. The way I heard it said is the Department of Corrections will provide reports from law enforcement. And I'm just concerned which Department of Corrections, probation, community corrections, or while they are incarcerated for the same reason. That is a departure. We in the past, these kinds of reports were received through the courts upon admission, and that kind of information isn't normally shared with any outside agency. You can get it from the police department yourself rather than wait for the Department of Corrections. So if you can answer that, fine. If not, maybe Ms. Black, who's here from maybe the Department of Corrections, could answer it later on when we recognize her.
Sure, and I'm happy to provide what I know, and then if the DOC has more to add, that's wonderful. But I think we've got a little bit of confusion here. The communication would actually be from the state's attorney to the intervention program, not from the Department of Corrections. What happens currently is that when a participant is ordered to a CBIP program, they show up, do an intake, and within a period of time, that participant has to provide their police report and the victim contact information. And so you can imagine there's an inherent problem there, because if I am in that program and I don't have the intrinsic motivation that Representative Pickett mentioned, then I have a motivation to delay providing that information, to maybe provide incomplete or inaccurate contact information to make it harder for the person I victimized to get help. So I don't know if that helps clear up sort of what the information flow would be.
Well,
I'm sorry for that confusion.
No, I'm still curious at what kind of information. When you said the state attorney, it could be the SBI, the State Bureau of Identification, with the types of crimes, or it could be the actual police report. But that's minutia. We'll talk about it. I'm just concerned, but thank you for making an attempt to answer that anyways.
I think you're right that it's so important to get it really clear so that we can make it happen. So in general, it would be from the district attorney to, or the district attorney's office to the program.
Good, thank you.
Sure, thank you.
Anyone else have any questions? If not, I will move on. In support of this bill would be Faye Lupi.
Thank you, Senator Deschambault. Senator Deschambault, Representative Warren, and members of the Committee on Criminal Justice and Public Safety. My name is Faye Lupi. I am a member of the Maine Commission on Domestic and Sexual Abuse, and I'm here today speaking on behalf of the Commission in support of LD 782. The Commission members recognize the value of CBIPs to the larger effort of a coordinated community response to domestic violence and fully support the recommendations outlined in the bill. Sections 1, 2, 4, and 5 of the bill address the name change from CBIP Certified Batters to Certified Domestic Violence Intervention Program. Using labels such as batterer criminalizes, punishes, and harms the person, as well as perpetrates an us versus them dichotomy, instead of dealing with the true nature of the problem. Changing the title to domestic violence intervention more accurately describes the important work being done and also reflects a global shift toward labeling the programs based on the behavior and not the person. I want to be very clear about Section 5. And that is the part of the bill that requires the attorney for the state, Generally, that's how the prosecutor, the assistant DA who handles the case, is required to provide the incident report and victim contact information to the domestic violence intervention program, thereby improving the information sharing with the goal of improving victim safety. This doesn't change the fact that this only changes the mechanism, because currently the participant in the program or the offender himself or herself is currently required to provide that information, the incident report and the victim contact information to the CBIP, to the Batterer program. That is currently required in section 3.4 of the Batterer standards. This change correctly situates the responsibility for providing that information with the system partner best suited to do that. The problem with the current system is, as director of our coordinated community response for 22 years and member of the CBIP Standards Committee, I have heard numerous reports about the hurdles that the programs and the participants have faced in getting this program. Our program in Cumberland County, the educator says about a third of the time he gets the report. And what this does is just changes the obligation to the DA to get that report directly to the Batterer program, allowing the victim to be notified if the program is starting and so on. That information is not shared. It is just used for promoting victim safety. I'm happy to answer any questions about this and about my experience with how this information exchange works and could work a lot better and more safely for victims.
Thank you, Ms. Loopy. Thank you for being here. Any questions? Yes, Representative Reckitt.
This is sort of an illegal thing. It's not really a question. I just want to say that Ms. Loopy is right. It's been very difficult over the decades to get that information if you're the perpetrator. So I think it's a good idea to do that. I'm only worried about the victim information. So.
And if I could respond to that, Representative Reckitt, it has not only been difficult, but it can also be dangerous, because if the perpetrator goes to get the report and then rereads it and gets all wound up again about it, that could be not safe. That could increase the risk to the victims. So you have both the problem of hurdles. How is the person supposed to get it, and how are they supposed to provide it, rather than having the DA's office, who has it, just getting it to the domestic violence intervention program director. And there's nothing in the standards that says that the person can share it. The CBIP director uses that for getting more context about what happened, and also notifying the victims about whether somebody is in the program, and if they have been terminated from the program as well, which is really important information for victims to know in terms of safety. And so that if they have the up-to-date victim information, it's really important for the programs to have it. And the standards right now require that they have it. So we're not making a big change. It's just who provides it is the change in the statute.
Thank you, Ms. Loopy. Thank you. Any more questions for Ms. Loopy? Seeing none, thank you. And I meant to ask Ms. Wyman, and I want to ask you as well, just if you'll be here at the work session, which is next week. I think there's just for a couple folks just, want a little more information about that, but I think we'll be able to get past it at the work session. So thank you. And next up, we have Ms. Black. You're here to testify in support.
Ma'am, thank you. Thank you. I don't think I'll offer too much different than what's been said, but just to voice the department's support and make sure that we get our testimony heard too. It's nice to be on the same side of things this afternoon as well. So Senator DeChambeau and Representative Warren, other distinguished members of the Criminal Justice and Public Safety Committee. I am Anna Black, Director of Government Affairs for the Maine Department of Corrections, here providing testimony in support of the proposed amendments to 782. As Chair Warren mentioned, in January of this year, the MDOC and the Maine Coalition to End Domestic Violence stood before you, virtually of course, to discuss our shared vision to end domestic violence. The DOC's contribution to this is through the implementation of what's currently called the Certified Batterers Intervention Program. In 2019, the MDOC expanded our ongoing partnership with MCEDV as part of the 2017 law that I believe Representative Warren mentioned. As this committee knows, originally that was just a contractual agreement, but the role, MCEDV's role was to assist with the implementation of plans for using the monies appropriate under that law for the CBIT program. But over the years, wonderfully, a shared commitment to honoring the experience of the victims while ending domestic violence through education has shifted into what we really consider a highly collaborative and solution-focused alliance. An example of this is the amendments presented for this bill that Chair Warren outlined, which were created in collaboration, as she mentioned, with MCEDV, and they focus on 3 specific things, which have been noted already, but I'll just mention them one more time. So we're clearing up terminology, identifying that a domestic violence intervention program is not a form of medical or psychiatric treatment, and of course creates the mechanism for information sharing. So we certainly hope that you agree that this bill improves the Certified Domestic Violence Intervention Program, which it's hopefully going to be called, and ensures peace of mind for the victims. Commissioner Liberty and Tessa Mosier, the Director of Victim Services, certainly plan to be part of the work session next week. Thank you.
Wonderful. Thank you for that, Ms. Black. Representative Reckitt. Oops, you're on mute.
I'm just wondering where the text of those amendments is. Is it in the committee materials or something? Because I have not seen them.
Oh, it should have been, yes, attached to my testimony, I believe.
Okay. I will look for it there then. Thank you.
Okay, thank you. And I'll make sure that it is there. I'm pretty sure that it is. Thank you. Any other questions for Ms. Black? Okay, thank you. Seeing none, let's move on to anyone here wishing to offer testimony in opposition to this bill.
No hands up, Representative.
Thank you. And anyone here as an attendee wishing to testify neither for nor against this bill, just raise your hand.
Again, seeing no hands.
Great. Thank you. Committee members, need anything from Ms. Orbiton before the work session? Seeing none there as well, I will close this public hearing on LD 782, and we will work this bill next week. Yes, Representative.
Yes, because of the length of the morning session and everything, we were planning on, my caucus was planning on having a brief caucus at noontime. With a half an hour going down, by the time we got lunch, we had no chance to. So if we could have about 15 minutes to just have a chance to just take a look at the bills we're going to be working on in just a few minutes, it would be greatly appreciated. If not, then we'll probably be having a lot of side caucuses, and I'd like to avoid that if we can.
Yeah, no, I think that's fine. We understand that. So can we try to be back at 5 minutes of 4 and then adjourn at 4? No, I'm just kidding. Can we try to be back at 5 minutes of 4?
Sounds good. Thank you.
Thank you very much. See you all in a few minutes. I think we're set, right, guys? We okay? And we'll just take a little break and then be back here together at 3:55? Okay, great.
That's it. I've been wanting to do this.
Well, that's what I was just gonna say. How come we just didn't change the rules and just
Hey,
do-
Deb,
Yeah.
Deb, can you hit mute
Couple of questions.
for? Can you hit mute, Deb, whoever's hosting?
Let me see if I can try to do it. Richard, we can hear you if you're going to be caucusing in there. I'm trying to figure out how to mute everybody.
Who do we need to mute?
Can you just mute everybody so we can't hear them caucusing in the room?
Yes.
Thank you.
I think we're good.
Thank you, Deb. All right, we're a few minutes behind, but it looks like folks are coming back into the room. Nice background, Deb. That is where I'm heading as soon as we are done. I am
Good
heading
idea.
to Res. I did take the little dogs out for a stroll over the lunch break, but we're going to go to the WOODS. I have to spell it because they know what that word is.
Yeah, you'd be in trouble.
Yeah. Oops, Lois, you're on mute.
Yeah, if you need a chipmunk hunter on your trip, you should take my cat with you, who appeared yesterday at the door with a chipmunk in his mouth.
Oh my goodness.
And, but I think the chipmunk eventually got boring and he left it, and we never found it dead. So I assume, since I know he didn't eat it because he never eats things, he just plays with them. I mean, 2 weeks ago, I saved a bird who he brought in, and I just picked it up with a dish towel, took it outside, opened the dish towel, and it flew off. You know?
Oh, good job.
It's playing dead to the cat, you know, to try to confuse it and not have it bite into it. But
smart.
He's a hunter.
Okay, well, let's get back to it. Oh, sorry, did somebody have something?
Madam Chair, can I ask that we either start earlier in the mornings, go a little later on Monday or Wednesdays? I've been up and down because my business has been calling me all afternoon, and Friday afternoons is, I mean, it's 4 o'clock on a Friday. My husband's actually home for the first time early.
Yeah, I'm with you. We're going to try to do this very quickly, and we all have work that we're trying to balance.
Right.
So I'm trying to crank us up here, keep us going. I think if we can really be a little faster on Monday and Wednesday, maybe we could make up for it on Friday, you know? So let's get right to it. Couple of changes just right off the bat. One, I was reminded by one of our members that we had promised a while ago that we were going to pick up pretty quickly the pretext stop bill, which is LD 417. I made a commitment when we tabled it that we would do that quickly, and I have failed on that commitment. So I am asking Ms. Orbiton to please, I do not care what day it goes on next week, Monday, Wednesday, or Friday, but please add that bill to our list of work sessions on Monday, Wednesday, or Friday. Secondly, LD 476, which is the first one on our list for this afternoon, the commissioner and the sponsor and all of the interested parties have a meeting scheduled for Tuesday. As we all know, everything is crazy and people have multiple bills and they're trying to get all of these things done in a timely fashion. So I would like us not to take that bill up today, since there's going to be a lot more information coming from that bill. It is my suspicion that if we take it up, we're going to talk about it for an hour. And then when we take it up again, we're going to say all the same things again. So I'd like to say we don't pick that up and we just deal with the three that we've got in front of us today. Ms. Orbiton, do we have to do anything official?
To reschedule 476?
Yeah.
No.
Okay.
No.
Great.
But why don't we, if you don't mind, can we just set it for Wednesday?
Perfect.
And set the pretextual traffic stops for Monday afternoon with 1 o'clock bills, both of them?
Perfect. Rep Morales, you guys are meeting on Tuesday, so Wednesday's fine. Oh. I think she's frozen. Okay, let's bookmark that. If it needs to change, I will let you know. So
Okay.
let's move on from that. If it needs to change, I will let you know. Let's get right to the work. The next bill is LD 477, an act to allow for fair restitution by providing that restitution does not include the cost of analysis of suspected illegal drugs.
I'm sorry, are folks waiting for me? My internet just went out.
Nope, you're fine. For your bill 476, you guys are meeting on Tuesday, so to work at Wednesday is okay?
That sounds great. Thank you.
Perfect. It's on Wednesday and pretext is going to be scheduled for Monday.
Okay.
Great. Okay.
Representative Warren,
Yes, Madam Chair. Hello.
I'll thank you for helping me out on this one. I will take over since this is your bill, okay?
Okay, wonderful. Thank you.
Yeah, go right ahead. Thank you, Ms. Overton. Go right ahead. Thank you.
I will, let's take a shortcut and I won't read the whole thing to you. This bill is, the bill analysis is posted online as they all, unless something happens, they all will be prior to the work session. This is LD 477 on the question of the cost of analysis of suspected illegal drugs being included in restitution. I won't take you through the testimony unless you really want. It's all right there. There was information, I'll take you to the information request. There was information requested with regard to the frequency and amounts of restitution for the cost of drug analysis from the Department of Corrections. Anna Black provided information saying that they have information on money distributed to Maine DEA as reimbursement for the cost of analysis of suspected illegal drugs. That includes lab testing fees, and it could potentially include some fees related to meth lab cleanup. And the numbers are there, and they run from 2016 at $46,000 to 2020, $36,798. Megan Maloney for the Prosecutors Association provided information from District 8, DA Todd Collins, saying that they requested in almost every case. I do not have numbers from the prosecutors, from the DAs. That's all. Thank you.
Senator Shambo, are you going to chair this?
Excuse me. I'm in the wrong frame of mind. Thank you. I apologize for that. I have, okay. Any questions of Ms. Overton on this analysis? Should we remove that from the page so I can see everybody? I'm going to recognize Representative Pickett. Thank you.
Yeah, I don't have any question for Ms. Overton, but I just was wondering, is the bill sponsor here by any chance?
Yeah, that's me.
Oh, sorry about that. Sorry about that. My mistake. I don't know where I guess my head's in a different place. It's Friday afternoon. I know, I just wanted to find out, did you have any discussion with CLAC in regards to their suggestion on this bill?
I was at the CLAC meeting when they discussed this bill, yes. One of the things that I heard them say was that if there really is a significant amount of cash, then use the forfeiture to fund the testing. That might be a way to meet everybody's needs so that it isn't folks who are struggling with substance use disorder, but it's people that actually have big trafficking operations, and there would already be an asset forfeiture involved. And I'm in favor of that if you'd like to make that amendment to the bill.
Okay, okay. I will go out because I don't think I can make a motion right at the moment. I don't, or can I?
You can.
I'm going to let it's a question. Yeah.
Can I make a? Okay, I wasn't sure. Thank you. So I would move ought to pass as amended, and the amendment would be that limiting the imposition of restitution for drug analysis to trafficking cases where the sentencing court makes a finding that the conduct underlying the conviction was motivated by profit as opposed to an attempt to pay for a drug habit.
Second.
Who was the second? Sorry.
So Susan DeShambo. He's
So unless there are any
Yeah,
questions
yeah.
of people, we could run the,
Yeah. Excuse me, Representative Page, thank you. Okay. Anyone else? I hesitated. Okay, here we go. Because there's feedback. I'm sorry, I was waiting for that. So it's been moved and seconded. The motion, does it have to be read again? Does everybody understand that? So we'll have a roll call to make sure everybody wants that, or should I have a show of hands, Representative Warren?
no, we'll need a roll call. It's an official vote.
Yep, okay.
All right, video on and unmute, please, for a roll call vote. Representative Warren,
Yes.
Representative Morales,
Yes.
Representative Reckitt,
Yes.
Representative Sharp is absent, Representative Lookner,
Yes.
Representative Pickett,
Yes.
Representative Costain is absent, Representative Rudnicki,
Yes.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Senator Lawrence is absent, Senator Seaway is absent, Senator DeChambeau.
Yes.
That's 9 yes, unanimous.
Thank you. Who, Representative Bacon? Could you mute yourself? Okay, thank you. It's very difficult. All right, so it's, we have an amendment. Any other questions or amendments, suggestions, or are we ready for a vote on the whole bill?
We just voted the bill. We're now
the whole
on LD 491.
Okay. All right, so we're all done with this one, correct? All right, thank you very much. 491. So now we're up to, LD 491, an act to create the crime of hate crime, false public alarm, or a report, and Senator Meermont's bill. Ms. Overton?
Yes, thank you. I will take the shortcut again. I won't read you all the way through the summary of the bill or the testimony. I'll scroll down through it, but you can take a look at your own screens at this if you want to. There was testimony in favor and testimony opposed and testimony neither for nor against. There were some suggestions that you could amend the civil rights law if you wish to do that instead of dealing with it in the criminal code. Also that you could deal with it in the criminal code as a permissible factor in sentencing. Both of those suggestions were made by a number of people, but they're contained in John Pelletier's testimony, which I'll leave in front of you for just a minute and then I'll take it down. The only other thing I would say is that there was some requests for information from the state police about false public report or alarm calls, and Major Bill Ross sent you some information. I forwarded it on to you yesterday. And it gives you information about false public reports. And if you needed more information, we could check to see whether Major Ross is here today.
Thank you. Does anybody have any questions about what we received? Any clarification? Excuse me? Yes. Ms. Overton, could you take down the your analysis, please?
Certainly.
Thank you. There we go. I have Representative Warren. You have a question?
Thank you, Madam Chair. I am wondering, I understand the motive, obviously. I think we all do. I don't think that the remedy is to create a new crime. And I'm wondering, just to get people's sense, and maybe Jane, you're the right person to ask this question first. So let me be clear. I'm not going to vote for the bill as is. I'm opposed to the bill as is. But I'm wondering, it says from CLAC that we could do specific sentencing enhancement directing courts to give special weight to any discriminatory motive that has been demonstrated when imposing the sentence. Would that be something new, or does that already happen?
I'm not aware that discriminatory motive is one of the factors that's listed in the law on the sentencing enhancements.
How do people feel about that? That sort of bridge from CLAC of just adding discriminatory motive to that sentencing, or a no-go? I'm just wondering what people think.
Who has their hand? Representative Pickett has his hand up.
Yes, thank you, Madam Chair. Yes, I agree with that. I think really right now there's probably certain prosecutors which take that into consideration in the first place, and judges that do, but to get it right in there in the sentencing thing, I think that's an important thing to do. I like that suggestion. And I also like the second suggestion of the act of making a false public report or alarm could be added to the list of conduct that can constitute a violation of a person's civil rights under Maine's so-called hate crime statute, which will authorize the Attorney General to bring a civil action to obtain penalties and an injunction for infringing on the civil rights of another. I wouldn't have any problem with having both of those, taking both of those suggestions and put them, amend the bill with them. But as the bill is written, without doing either of those things, I'm with Representative Warren. I can't support it as written.
Representative Warren, I have a question. Could you please explain to me what you just read? Because maybe my head's in a fog right now, but I don't seem to understand that.
I was just reading two of the suggestions made by CLAC. So first of all, I really appreciate Senator Marymount bringing this forward. I think it's a very important piece to discuss, but I think it is already covered. One of the things that CLAC suggested was possibly just adding those two words.
Yep, I get it now. Thank you. That came yesterday and I was not available to read that, so I just looked at it. I understand it now. Thank you. So has someone made a motion to that, to add to that?
We don't have a motion yet, but Representative Pickett and I were both sort of just seeing how do our colleagues feel about that. Yes. Oops, sorry.
Let me see. Representative Morales?
Yes, thank you, Madam Chair.
I feel similarly, I think, and I would like to just hear a little bit more, Representative Pickett, on the second amendment that you were talking about. But I agree with both of you that I am not in favor of the bill as it stands. I do think that the code addresses hate crimes. But I wanted to, Representative Pickett, could you explain number 2 again? And I know I have it in my notes somewhere from the hearing, but I can't locate it right yet.
Well, I was just reading from the CLAC testimony, but is anybody from CLAC here?
I don't see anybody.
Because what it says, I'll read it again, Representative Morales. They had 2 suggestions, and their second suggestion was, it says here, second, the act of making a false public report or alarm could be added to the list of conduct that can constitute a violation of a person's civil rights under Maine's so-called hate crime statute, which authorizes the Attorney General to bring a civil action to obtain penalties and an injunction for infringing on the civil rights of another.
I see. So it's a money judgment.
Right.
Right. I'd be in favor of that. Thank you.
Okay, good.
Yep.
Of the second one or the first one?
Of both of them.
Oh.
Okay, I think we should choose one or the other. Right? I think they're saying here are 2 options of how you might deal with this. Am I wrong? Maybe I'm wrong.
They're suggesting 2.
2 alternatives.
It's either.
Yeah, I think sending something to the Attorney General is a whole different level that I don't know I'm quite prepared for. The other one just added an enhancement to a sentencing. It's already a crime.
Yep.
Yep. And it does go beyond more the scope of the Criminal Justice and Public Safety Committee, and it's more into judiciary. I agree with that. Okay. So I'm for number 1.
Others comfortable?
Representative.
Yeah, thank you, Madam Chair. Yeah, just for clarification, it says to address such crimes when they are based on a discriminatory motive. CLAC suggests 2 alternatives. So I guess we could say it's one or the other. If I was going to pick one or the other, I would go with the first one. I think the sentencing one is the best one to actually go with. And so if we're going to amend it with that first one, I would be willing to support that.
Representative Morales, your hand is still up if you wish to speak or not. Okay.
No, I'm sorry.
You
I'm
wish
not
to
sure how to
speak?
take. No, I don't.
Okay, all right. It's just a little tweak. So now we've got somewhat settled. Does someone at least want to make a motion to the first suggestion that came? Oh, Representative Warren, you have your hand up. Thank you.
I was going to make a motion, but it looks like Representative Rudnicki may have a question. I don't want to preempt that.
Okay, yes. Representative Rudnicki.
Thank you, Madam Chair. So based on what you're saying about using the CLAC, are we basically throwing out this and just adding a sentencing thing? Does that violate the rules of any type of public hearing on what you're doing then? Because if you're just gonna, because basically you're rewriting everything. If you're just gonna put that one piece in and throw out the whole thing and just that one little piece.
Yes, that is totally within, that's a good question. We could even change the title. We're not going to, but we could. Yes, that is absolutely part of the purview of the committee's work.
Okay.
You good?
Thank you.
Okay. And I see Representative Lookner has a question as well.
Thank you, Madam Chair. Just before we vote on this, so we are not creating a new crime here is what the proposed amendment is. We are just giving more leeway in sentencing to judges who, if it's demonstrated that there is a discriminatory motive. Is that correct? Is that?
That's exactly true.
Okay.
That it'll just be in the sentencing. They'll sort of look at that as an elevated factor when the judge is doing the sentencing. So it still is focused on this idea of the hate crime false public alarm, because it isn't just going to be a false report. It's also because it's motivated, it's motivated on discrimination. Sorry, I can't talk anymore. Was that helpful or not helpful?
Yes, very helpful. Thank you.
Okay. So the whole bill will be replaced. We'll add something into the sentencing structure as opposed to into the code, the new crime.
Okay, copy that. Thanks.
And Senator, it looks like you have a couple more hands up.
Thank you, Madam Chair. Just one more thing. So if we take this vote, it passes. Ms. Overton would come back with the actual language before we report it out, correct?
Absolutely. Another great question. And that will always happen. You'll get a chance to look at it again. If you're not okay with it, we've got to tweak it a little more. So yes, that's absolutely what will happen.
Okay, thank you.
Yes, thank you, Madam Chair. I just wanted to echo the fact that, yes, I don't think anybody here with this particular bill was in favor of adding a new crime to the. That's not what our goal was here. It was dealing with a class of crime. We're looking to just take and make it so that we could get something out of the bill without making a new crime. And I think that's important. But I see the bill sponsor is here, and if I may, I just wonder if the bill sponsor is okay with what we're thinking about doing. What's your feelings on that, if that's appropriate?
Thank you. That's a good question, Representative. Thank you for that.
And thank you for the question. And I don't have a problem with what you're trying to do. It makes sense in a way. A little part of it is we heard that trying to enforce intent or prove intent when the crime is attempted to be used will be difficult. And so all of what you've said makes sense. And I can't be that person who is a young Black man in our culture who's been through some pretty horrific experiences, or watching the New York situation that precipitated bringing this bill, and then say for sure, how does that feel? How does that represent a population that might have something like this used against them, and possibly successfully, depending on whether someone's filming it or not. I know the difficulties with it too. So no, I like what you're talking about. And I hope that it solves the problem, deals with the problem, and makes people feel like they're protected under the laws that we know work. So thank you very much for checking.
Thank you, Senator. Senator DeChambeau, you're on mute if you are talking, and I think you probably.
Yes. And I guess I was talking to the people in the room and they heard me, so thank you. All right, so we've settled on which part, so we haven't made a motion on that particular part, have we? Representative Warren?
Thank you, Madam Chair. I make a motion ought to pass as amended, striking the entire bill and using the first amendment recommended by CLAC, which is to insert those words into the sentencing. And Jane, I don't know, maybe you can figure this out and bring it back to us in the amendment review. It may need a different name or a name tweak, and I can't remember what the rules are around that, but it does matter, so.
I'll second that.
We always have to change the title to match what's done in the bill. So
Awesome.
if you change quite a bit of the bill, then we change the title.
I'll second it.
It's been moved and seconded by Richard Pickett. You want to touch your? Thank you. All right. So we will have a roll call. Unless anybody has any questions, we're all set. Thank you. No, go right ahead.
Video on, and please unmute for a roll call vote. Representative Warren.
Yes.
Representative Morales.
Yes.
Representative Reckitt.
Yes.
Representative Sharp is absent. Representative Lookner.
Yes.
Representative Pickett.
Yes.
Representative Costain is absent. Representative Rudnicki.
Yes.
Representative Newman.
Yes.
Representative Pluker.
Yes.
Senator Lawrence is absent. Senator Searway is absent. Senator DeChambeau.
Yes.
The vote is unanimous with 9 yes, 4 absent.
Thank you. Right now.
Thank you.
Representative Pickett.
Thank you, Senator.
Okay. Representative Pickett. Thank you. We're down to our 24th bill of the week. Makes us feel good, doesn't it? LD 514, an act to establish and promote a system of safe disposal of expired marine flares. And we're gonna have fun with this. Thank you. Ms. Overton, thank you for presenting this.
Okay. Once again, I won't read it all the way through. I did outline on the bill analysis, the testimony that was given on the bill. And there was testimony for, none against. There was some neither for nor against. In the neither for nor against, the State Fire Marshal Joseph Thomas spoke of having over 2 tons of expired marine flares awaiting proper disposal, since his office does not have the high intensity incinerator that's necessary. The fire marshal did say that it would cost $41,500 for the needed mobile thermal destruction unit. Michael Allen from DAFS submitted written testimony, neither for nor against, and he spoke of the concerns that Maine Revenue Services has about a 25 cent per flare fee to be paid at the time of purchase, saying that that could place a burden on small retailers, and he estimates a cost of $11,000 for computer programming. There was information requested on current safe disposal methods and disposal of flares used in highway transportation, such as by commercial trucking companies. Representative McCrate sent information to you. I believe it arrived, perhaps last week, stating that the biomass incinerator Eco Maine is not able to take on this disposal function, and that she was continuing to talk with the Department of Environmental Protection regarding highway flares. She also sent an email this morning that I forwarded on to you. And in case you didn't have a chance to read it, I will just summarize a little bit of it with regard to the highway flares. DOT says they don't use them. And DEP says they would not have the same complexity with regard to disposal as marine flares, since a marine flare has to have a sort of explosive in it to make it go up in the air in order to operate. And a highway flare is operated at ground level. She also repeated her discussion with Eco Maine, and that appears not to be a viable option. That's all I have.
Thank you.
Representative Reckitt, followed by Representative Morales.
I move on to pass.
I second.
Okay,
Third.
moved and seconded. I have a question. I want to make sure I know what we're moving. We're not adding, are we, chapter 727, 5011? That's the one DAF said not to add or suggest. Are we asking for a 25 cents?
If I could, no, my intent is for this bill to pass and go to appropriations, and please God, let them give us $41,500 to get rid of these flares. So anyway, I'm sure that Representative McCray is even tireder than I am of this topic, but I think it's at some point we've got to do this, and it's going to get worse, not better, if we've already got, I can't remember how many tons piled up already. So my intent is to pass it as written. Forget the 25 cent stuff.
Okay.
So I guess it's as amended if the 25 cents per flare was in there. So
No.
so it's ought to pass as amended and send it to approps.
Since you answered my question, and I appreciate that, I probably was wrong. It was attached. It's a different MRSA. And I don't think it's part of the bill. I hope it's not. And Mr. Pickett, I mean, Representative Pickett, I see your hands up, but I'd like to hear what Jane has to offer while we were just discussing that. Ms. Overton?
The 25 cent fee is in section 2 of the bill. It's on the last page. So if you are not interested in the 25 cent per flare fee, you would move ought to pass as amended section 1 of the bill only, taking out section 2.
Yeah, that was my intent.
Then we'll need to know that the second of Representative Morales also agrees with Representative Reckitt.
I do. I was going to pass it as the sponsor had drafted it. I believe she's worked on it for years. It's narrowly tailored, it's necessary. But if the will of the committee is to go as amended, I will go with that as well and withdraw my my second.
Senator, could we hear from the sponsor?
Oh, there she is. I'm sorry. Yes, thank you. Representative McCray.
Thank you. Thank you, everybody. I'm absolutely fine if you choose to remove the 25 cent fee. What's really needed right now is an incinerator, especially because the other one can't be used. That the fire marshal had been using the smaller one, can't use it now. The other part of the bill that is really important is that this would update information on all agency related websites around how you dispose of flares. As I testified, all the information out there is wrong, illegal, harmful, dangerous. So that passing the bill means we educate the public, and it means the fire marshal would hold collection events as well as, you know, the individual collection. But for example, Harpswell has 3 fire stations. They could take the mobile incinerator to a location where fishermen are close by or recreational boaters are close by, and they can bring the flares rather than keeping them in their basements where they could cause a lot of damage if there was a fire. So I'm fine with section 1 alone because the other parts would stay.
Always happens.
Great.
Then my second stands.
Excuse me? Okay, could I recognize Representative Pickett, followed by Representative Renicki?
Thank you, Madam Chair. Thank you, Representative McCray, for being here, and thank you for all your hard work. And I wish we could have got the $41,000 last year, but it didn't work out. But it is definitely a very necessary bill. It's causing a lot of not only havoc, but it's a public safety issue. It really is, especially for people that don't know what to do with them and are keeping them stored, as your testimony and others have spoken about. I would not have been able to support it if we would have had the other $11,000 added on there that for taking the 25 cents, because we were kind of taking one thing and it was making the bill worse. It was trying to make it better by doing it, but it actually made the bill worse, because we're going to be lucky to get the 41,000 at the with appropriations and stuff, and I certainly hope we get it, but I don't think we would have got the 52. Right. So anyways, but thank you for all your hard work on the bill, and hopefully we get this passed out of here, and hopefully the AFA puts it in, and we get this thing taken care of once and for all.
Thank you.
Thank you, Representative Pickett. And Representative Renicki.
Thank you, Madam Chair. I just have a question because this definitely isn't anything in my wheelhouse, and I have not done the research that the sponsor has done. But this is going to be an ongoing concern, correct? Where, I mean, there's always going to be flares that need to be disposed of. And buying the incinerator, I understand that part of it. Could you just maybe tell again, the 25 cents that you had originally put in the bill to add to every flare, and I'm not one that will normally add taxes, okay, or fees, but that 25 cents, was that due to help with the ongoing cost as we go on? Because at some point there has to be additional cost. Is that cost, can that additional cost ongoing be absorbed within the fire marshal's budget? Is that the plan? Or was the 25 cent fee per flare a way to cover that without touching the fire marshal's budget?
Well, can I respond to that? Is that a question for me?
Yes, go right ahead.
Thank you. You know, this bill has had several presentations, and the most brilliant idea turned out to be illegal according to the Coast Guard by federal law. So couldn't do that. So this is what the fire marshal and I have come up with. The 25 cent, yes, it was to cost in the future, but honestly, if we have a new incinerator, it's going to last a very long time. And the original incinerator, the smaller one that can't be used at this point for flares because of their high temperature, was purchased with a grant. So you'll notice that the way the bill is drafted, outside funds could be used. So I've been working on that as well to try to get this funded without having to use general fund dollars. I can't say that I'm going to be able to do that, but that provision is there so that that possibility exists, and I am doing all I can to do that. So if we're able to find other sources, such as organizations that support fishermen, support recreational boaters, then the cost will be shared. That would be my goal. So that's why I feel the 25 cents. With Representative Pickett, the DAFs didn't testify. I didn't know about their testimony. I guess I could have looked and found it, but knowing that additional cost, I don't think I would let that go and go with the incinerator for now. And I'll keep working to get it funded.
All
And
right,
if,
thank you very much.
yeah, thank you. Thanks for the question. I'm happy to talk about flares all day long, Representative Rudnicki,
Loves it.
as some of
Yeah,
you
I'm
know.
Oh, okay. I was gonna demonstrate to Representative Rudnicki from what I'm reading under administration. Even if we had collected the funds of the 25 cents fee, it would not have been dedicated to Marine. It has to go to the general fund. So I'm not in favor of taxing people either 25 cents. And before we take a vote, Representative McCray, I think this whole committee will be lobbying the Appropriations Committee for you, okay?
Absolutely.
Not that
Thank
we
you.
don't want to see you again, but we don't want you back here again. Not you, but the subject matter. Okay.
Thank you. I'm for that.
Okay. So Representative Pickett.
Yes, thank you, Madam Chair. And Representative McCray, we'll all be there for the first time that they have a filling of the incinerator.
Oh,
We'll
wonderful.
we'll call it our 4th of July, no matter what it is.
Wonderful.
Now we're
It's a
talking
date.
fun. Now we're talking fun. All right, we ready to vote? Whoops, Senator, you're on mute.
No, I'm on mute. I'm trying to lower my hand. Okay. So we're all set with the wording and we know what we're doing, and thank you. So yes, Ms. Fay, you may call the roll call.
Video's on, and please unmute for a roll call vote. Representative Warren,
Yes, times 2,
2 yes.
or actually times 3, since this is my
Yes.
first time voting yes.
Representative Morales,
Yes.
Representative Rackett,
Yes.
Representative Sharp is absent. Representative Lookner,
Yes.
Representative Pickett,
Overwhelming, yes.
Representative Costain is absent, unfortunately. Representative Rudnicki,
Yes.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Senator Lawrence is absent. Senator Searway is absent. Senator DeChambeau.
Yes.
That's it's unanimous with 9 yes and 4 absent.
I can't thank you enough. Thank you,
Oh,
thank you.
no, we thank you.
And we'll have that party, Representative Pickett. Thank you. Thank you, everybody.
Thank you, Jay.
Yep. Okay. I am now going to start charging 25 cents with Representative Pickett every time he leaves his mic open. So
I'm
this
going to start charging. I was thinking about what I might charge, and I was thinking money for when I had to tell people they were muted. But I think instead I want ice cream sandwiches.
Okay. Well, oh, yeah. And you've done so well. Okay. This concludes the.
They'd never make it to you. They'd never make it to you because I like them too well.
Yeah, they're good.
All right. So this concludes LD 514, and rightly so, to end this week on a high note. This makes us all feel great, finally on this one. I want to thank all of you, and especially Representative Warren for helping me out in many occasions. So this has been a tough week. Next week is not going to be any easier. So we're on to next week. have a great weekend at 60 degrees or so. So enjoy.
You too, Senator. Thank you. Bye, everyone.
Bye.